Good afternoon. Welcome to the Appellate Division First Department, or arguments for today, February 3rd. I'll call the calendar. You already know what the time is allotted, but I will state again. And additionally, you do not have to respond, obviously, you will not be responding to the call of the calendar. People v. Tyler Johnson, 5 and 2 for the appellant, 5 for respondent. Patton v. Genito, 5 and 2 for appellant, 5 for respondent. T. Albert versus Shaquana M., 5 and 2, 5 and 3. Aspen American versus 6 and 2 and 6. 160 East 84th Street, 87th Street Cherry, 87th Street Cherry versus New York State Division of Housing, 10 and 4 and 12. People versus Derek O'Mara, submitted. Polanco versus Durjaj, submitted. Brandnow versus Barriqua College Development, 5 and 2 and 5. Schultze Roth versus Metropolitan 919, 6 and 2 and 6. People v. Ken Goodwin, 6 and 2 and 6. DC 37 versus New York City Department of Education, 5 and 2 and 5. Genito versus Shea, 6 and 2 and 6. Canal Rubber versus 6 Green Realty, Canal Rubber versus 6 Green Realty, both cases. Only one will be argued, 5 and 2 and 5. Berkshire Hathaway versus HIG Capital is submitted. Condor Capital versus CALS Investors is submitted. First case up for argument will be People versus Tyler Johnson. Let me just remind your attorneys, please keep your mics muted unless you are actually arguing that case. Also, please keep in mind we can see you, so if there's any agitation, there's talking, etc., it does become distracting. So you can turn your camera off because you'll be able to turn it back on. Also, if for some reason you get kicked out or you have some type of technical issue, just leave, come back in, or you can actually call, okay? So again, first case up is People v. Tyler Johnson.
Good afternoon. Sarah Lynn from the Center for Appellate Litigation on behalf of Appellant Tyler Johnson. May it please the court. In this case, a minimum sentence of 5 years incarceration is enough for the purposes of punishment. In the interest of justice, this court should reduce Mr. Johnson's sentence to the minimum.
So he received 7 years with 5 years post-release supervision. Is that correct? That's correct. And you are looking for 5 years with 2.5 years post-release supervision. Is that correct?
That's correct, Your Honor. At the time of the incident, Mr. Johnson was only 22 years old, and this was his first offense in New York. Consideration of his relative youth and immaturity supports a reduction to the minimum. His actions here, waving around a gun and firing shots out of a taxi in the middle of the night, were rash, reckless, and impulsive. But they were illustrative of a young person's immaturity and bad decision-making. Immaturity doesn't exempt Mr. Johnson from punishment, but it does support a reduction to the minimum of 5 years. 5 years is not an insignificant amount of time. It's sufficient.
Counsel, what was the maximum that he was facing for these charges?
I'll get that to you, Your Honor, on rebuttal.
Oh,
but the minimum was 5 years.
But the maximum was what, 25?
I don't have that off the top of my head, Your Honor.
Well, yeah,
I believe it is.
Yeah,
25.
it is, because it was kidnapping in the second degree. It was a little bit more than just waving, which I'm not saying that that's not egregious as it is. To be waving a gun and firing a gun out of a cab is serious as it is. But we're also talking about how he got into the cab and the kidnapping, because he forced the driver of the cab, and we're talking about 3 cabs, by the way, but he's forced the driver of the cab to drive off. So that's where the kidnapping comes from.
That's correct, Your Honor. These actions, we are not denying that they were rash, reckless, impulsive, but they're illustrative of his immaturity, Your Honor. And 2017, Mr. Johnson was abusing alcohol, drugs. He was hanging out with the wrong people. But Your Honor, he has the time and space to mature and grow. We are asking this court to exercise their authority in the interest of justice to reduce his sentence to 5 years. 5 years is sufficient for the purposes of deterrence, rehabilitation, isolation, and retribution. In 2017, the same year of the offense, Mr. Johnson completed a 3-month-long drug treatment program. It shows that he's motivated to rehabilitate himself. If he's able to be released at the minimum sentence of 5 years, he'll be able to go back to his friends, his family, and community who will be able to support him in his endeavor to rehabilitate himself and mature and grow. And so we ask that this court exercise their interest of justice authority to reduce Mr. Johnson's sentence to the minimum. Thank you.
Counsel, I just want to be clear, in addition to the kidnapping, were there also allegations as to a female who was also present with him?
That's correct, Your Honor. On the complaint, there are allegations that he had allegedly punched her. However, those facts were not pled to at the plea, and it was clarified by the prosecution on page 6.
Thank you. Yes, people?
Good afternoon, and may it please the court, Faith Petrolio for the people. The court should affirm defendant's sentence because he received a fair and appropriate sentence as a part of a negotiated plea agreement. As an initial matter, defendant's excessive sentence claim is foreclosed because he validly waived his right to appeal. But in any case, defendant received a fair and appropriate sentence. He received the exact sentence for which he bargained, and the sentence was a lenient one, considering that in the course of 1 hour, defendant fired 2 live rounds out of the window of a taxi, racked the slide of the gun in view of the driver of another cab, and in a third cab, brutally attacked his girlfriend, and then pointed the gun at the driver and ordered him to drive. So he was initially facing multiple felonies, which would have led to many, many years in prison. And even if he had only been convicted after trial of the 2 felonies that he pled guilty to, in this case, he would have faced up to 40 years in prison, or he could have faced up to 40 years in prison, since the second-degree kidnapping was a 25-year and the weapons charge was 15 years. And he could have been sentenced consecutively, but instead he only received 7 years, just 2 years above the minimum. So his the plea agreement that was reached was very beneficial to him, and so it should be affirmed. If there are no further questions, we ask that you affirm.
Thank you. Were there any questions from anyone? No? Thank you. Ms. Lynn, you have 2 minutes on rebuttal.
Thank you, Your Honor. Here, the appeal waiver was invalid because, first, the court did not distinguish that the right to appeal was separate and distinct from the trial rights that he forfeited. In addition, they mischaracterized the right to appeal, or the waiver of appeal, as a complete bar to appeal, which case law shows that this is not the case. And so
I'm looking at the appeal waiver. I don't see that it says that it was a complete bar.
The court stated, yes, Your Honor, the court stated that the case would basically be done on page 6, and that it would be the end of the matter as far as the courts are concerned. This characterizes the appeal waiver as being a complete bar to appeal.
Well, it went on to talk about the fact that he could, that there was, that it doesn't, I'm sorry, that it was also a written waiver. It says, I understand that this waiver does not apply to any of the 4 following issues: constitutional speedy trial, challenge to the legality of the sentence promised by the judge, issue as to my competency, or the voluntariness of this waiver.
That's correct, Your Honor. There was a written waiver. However, the lower court never confirmed directly with Mr. Johnson that he understood or even read the contents of the waiver before signing it. They only addressed the written waiver with defense counsel. In People v. Callahan, the Court of Appeals requires that, or states that, a knowing and voluntary waiver cannot be inferred from a silent record. Here, the record is silent as to specifically the written waiver. And so even if the written waiver correctly characterizes the right to appeal, and the appeal—
Well, his attorney counsel confirmed that he had reviewed the written waiver and then had the defendant review the waiver and sign the waiver. So why is that insufficient where counsel affirmatively states that he conferred with his counsel, he read it over with his counsel, with the defendant. The defendant read it over, and the defendant then signed it.
It's insufficient, Your Honor, because the court never directly confirmed with the defendant himself.
So even though the attorney says, I showed it to my attorney, I showed it to my client, He's reviewed it. I've gone over it with him. The defendant signs in open court the waiver. You're stating that the judge still has to say to the defendant, is your attorney telling the truth?
Yes, Your Honor. The court should have confirmed directly with the defendant. In
And
People
this
v.
is based on
Seaberg,
what case?
on People v. Seaberg says that a court must take into consideration the age and background and experience of the accused in determining whether the appeal waiver is valid. Here, Mr. Johnson was a young man. This was his first experience and encounter with the New York criminal court system.
Had he had a prior in Florida or something, or was that after this case where he had a something about a fraudulent driver's license or something, I think?
Yes, that's correct. There were priors in Florida. However, this was his first experience with the New York system. And so whether or not there was an appeal waiver in Florida, I'm not sure, Your Honor. But here, the court should have taken into consideration his youth and his inexperience with the system in order to make sure and ensure that he knew what right he was giving up.
Thank you very much, counsel. The next case is Patton versus Genito.
Good afternoon, Your Honors. This is Gregory Parada from the law offices of Kevin Westerman on behalf of defendants appellants Marco Genito and KIT Transportation. Just by way of background, Marco Genito is the driver of a flatbed trailer. At the time, it was owned by KIT Transportation.
Yes, counsel, you're familiar with the record. So what evidence was presented by your client? You represent Genito?
Yes, I represented Genito and KIT.
So what evidence was presented by the defendants in order to rebut the prima facie showing by the plaintiffs?
Sure. Specifically, there's a driver's accident report that was prepared in connection with this accident by the driver, Marco Genito. When he immediately returns to KIT headquarters immediately after the accident, he meets with Susan Tratnak, who is KIT Transportation's president, owner, and operations manager.
Right. So that accident report, how would that be? How it's called a driver's accident report?
Correct.
How would that be properly admissible for purposes of the motion for summary judgment?
Sure. We posit that the driver's accident report was admissible as a business record exemption to hearsay, following that the record satisfies all the requirements under the First Department case law, specifically prepared in the regular course of business, performance of the business functions, and it was prepared nearly contemporaneously to the occurrence of the event.
Mr. Perota, what details are there in the accident report that support the application of the business record exception, other than a bare conclusion saying he had a duty to provide this?
This accident report in question is prepared on this type of letterhead in connection with every such accident involving a KIT driver.
But Justice Moulton?
Mr. Perota, does it say, does the Tratnak affidavit say that we kept these records for our business purposes? And does it exclude the possibility that the reports are purely for litigation, which of course would take them outside the exception?
The Tratnak affidavit says that KIT keeps such records in connection with every accident involving their one of their drivers, which in fact negates the fact that it would have been prepared solely for litigation purposes, because it's prepared in all manner of the trucking company's business, not just as in connection with litigation.
Well, couldn't any accident give rise to litigation though?
Potentially, but it would behoove the trucking company to maintain an accident report in connection with any event that is an accident, whether litigation follows or not.
Would you concede that the statements made by Ms. Tratnak herself are hearsay? Because she also sort of repeats what's in the accident report. We can't consider those statements by Ms. Tratnak, correct?
Correct. The chief document that we're seeking to have admitted is the contents of the driver's accident report, where Mr. Genito memorializes his version of the events in question. Now, although Mr. Genito was precluded, we don't believe, and it's our position that his preclusion shouldn't affect KIT's ability to mount its own defense here, specifically through the submission of the driver's accident report in rebuttal to plaintiffs' application for summary judgment, which was granted by the lower court. And in so doing, the lower court found that the contents of the Tratnak affidavit were, hearsay and prepared in opposition to plaintiff's motion for summary judgment, which we contend in our own right they're an admissible business record.
But the bulk of the information provided in the driver's accident report was provided by Mr. Genito. So did Mr. Genito, don't you also have to show that Mr. Genito had a business duty to prepare the document, or at least to give competent information for preparation of the document?
Yes, and we believe we've satisfied that burden, specifically since Mr. Genito, immediately after the accident, telephones KIT headquarters and speaks on his cell phone with Ms. Tratnak. The accident occurs as Mr. Genito completed a delivery and was on his way back to KIT headquarters in completion of the delivery. So he was already on his way to KIT, and then he eventually completes the journey and returns to KIT. And at that point, he fills out the driver's accident report in her presence.
Thank you. Any of my colleagues have any questions? No? Thank you. We'll hear from your adversary.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court. My name is Morgan Corley. I'm an associate of Trollman Glazer, Corley & Lickman on behalf of respondent Britta Patton. Now, a crucial element to this KIT accident report that the appellants failed to acknowledge anywhere in their papers, let alone reconcile with the extensive case law that we provided in our brief, is the fact that the statement by Mr. Genito about how the accident happened, which is the sole basis of this appeal, is completely speculative, because at the very conclusion of that statement, he says, and quote, "I never seen her." So to say that this creates an issue in fact as to defendant's liability or the respondent's comparative negligence is based on speculation. Moreover, this does not meet the foundational requirements of the business record exception, because we do not know how Mr. Genito came to learn about this alleged squeezing of her car in front of his vehicle and, stopping the vehicle as he contends in the statement. It does not identify a source of the information, and because he concedes he did not see her, we have to conclude that the source is not him. Now, because Mr. Genito is precluded from offering an affidavit or testifying, there's no way to ever reconcile this speculation, and a jury could not make a conclusion as to negligence based on pure speculation. This is the only piece of evidence that the defendants have offered in opposition to our motion. They've provided no non-negligent explanation for the collision, and even if we were to accept the statement as true and ignore the fact that Mr. Genito concedes that he did not see her prior to the accident, the appellants have submitted no case law that shows my client, switching lanes and stopping on her brake would show comparative negligence or would relieve the defendants from any liability. They cite a number of cases in their reply brief, which I have not had a chance to distinguish, but none of these cases are fact patterns that resemble the instant matter. Ms. Patton testified unequivocally that during this accident, it was Memorial Day weekend, the traffic was heavily congested in a stop-and-go manner, and the case law is clear that when traffic is congested, a driver of a rear vehicle has a duty to maintain a safe distance and be aware of the surrounding traffic conditions. The defendants never contested this fact, and they have no ability to, because Mr. Genito refused to participate in discovery and is precluded from testifying at trial. The cases cited on reply all involve situations where a car abruptly stopped in the middle of a lane where traffic was free-flowing. If I quote Baez-Pena versus MM Truck and Body Repair, which the appellants cite in their reply, it specifically states that, quote, the rear driver could have, quote, reasonably expected that traffic would continue unimpeded. And in Newell versus Bronson, which the appellants also cite, it states that there was a sudden stop in the unobstructed moving lane of traffic. And these cases all distinguish those matters where an abrupt stop couldn't have been anticipated by the drivers behind because the traffic was free-flowing. That's not the circumstances here, and the appellants have submitted no case law where a fact pattern, such as this fact pattern, taking the statement as true and ignoring all of the issues with its admissibility, there's still no non-negligent explanation offered by the defendants to justify a reversal of the underlying decision.
Thank you. Any questions? Thank you. Mr. Gregory, you have 2 minutes in rebuttal.
Sure. Just with respect to the issues raised by Ms. Corley, we contend that we have raised a non-negligent explanation of the events in question here. Specifically, even as briefed in plaintiff's own version of the events, she's seeking to evade an erratic driver. Therefore, she pulls in front of my client. And then in my client's accident report, she presses on the brakes.
But he says he says he never saw her. So how, if he never saw her, then how would he know that this is what occurred?
Perhaps he says he never saw her prior to her pulling in front of the truck and pressing her brakes. In any event, the accident occurs as the driver makes a sudden movement from being in front of Mr. Genito's truck. She pulls over onto the shoulder, in which case she's rear-ended. But just specifically with respect to some of the points of law addressed by Ms. Corley, there's no preclusion against the jury taking into account plaintiff's potentially comparative negligence in such a case as here, where even if it involves a rear-end accident. And specifically, we contend as well that it wasn't the province of the trial court, and they committed reversible error when they struck specifically KIT's defense of comparative negligence, because here the jury should have been able to take into account the actions of Ms. Patton as she, sought to evade an erratic driver, driving on the throughway and pulling in between two trucks and then making a sudden move to pull over onto the shoulder that resulted in the accident.
Thank you. Any questions? No, thank you very much.
Thank you, Your Honor.
Next matter is Albert T. versus Shaquana M. Yes, you may proceed.
Good afternoon, Your Honors. My name is Janet Newstetter. I'm from the Children's Law Center. We represent the child appellant in this case. Our client at this point is 11 years old. She was 10 when the events involved here took place. It's our position that the family court in this case abdicated its most basic responsibility, which is to always protect the welfare and best interests of the child, when it granted the writ sought by the father in this case without conducting any sort of hearing and based solely on the existence.
Let me ask you something, because it seems to me that it's clear that the court did not engage in a best interest analysis. And the court seemed to be saying that it didn't do so because it did not believe it had jurisdiction. So do you want to address that issue? Sure, Your Honor.
My position would be in the first instance that if the court had no jurisdiction, then it shouldn't have made any order at all. If it doesn't make any sense on the one hand to say, I can't do any kind of best interest analysis. However, I'm just going to say, I'm going to enter an order directing the return of this child. So it should have been one way or the other. The court either should have said, hands off, go to New Jersey, go wherever you need to go, or I need to do my job, the whole thing. I can't just do one or the other. The other thing, honestly, is, we've argued there was no jurisdiction there. On a lot more reflection, I'm not 100% sure about that. I think it's an incredibly complicated question, and I don't think it was correct for the court to make, in effect, a decision about jurisdiction in the face of a lot of contradictory information and without giving anybody an opportunity to weigh in on the issue. For example, the father who filed the writ said in the very same day, filed a writ in Kings County seeking the return of the younger child and said he lived in New Jersey. On the very same day, that's the writ that was dismissed for his failure to appear. But on the very same day, he filed a writ in the Bronx saying that he lived in Brooklyn. And then again, on the 10th, this is the writ that was ultimately granted, he said he lived in Brooklyn. However, on the record, 2 or 3 days later, he said, why are you investigating in Brooklyn or in New York? I live in New Jersey. And he kept on going back and forth about where he lived. Consequently,
Counsel, isn't it a fact that, that there is no record from NYCHA of the father living at the address that he gave?
That is correct, Your Honor. That was from earlier. I mean, in all honesty. But yes, there was such a record that was, I mean, there was so much evidence available and there was so much inconsistency and back and forth.
And then did he not also state that he lived in Florida?
At one point he did. And interestingly, in March of 2021, when this consent order was entered, the one that this court was relying on as that's it, done deal. I'm not going to look any further. Both parents at that point said there was a virtual appearance, and both parents said they were at their homes in Florida. So, I mean, I don't think there's any question, honestly, that he lived with the 3 children. Only one is at issue here, but with the 3 children in New Jersey, at least directly before these events. The older 2
Counsel?
children were.
This
I'm
is Judge
sorry.
Gonzalez. In your view, was there any exigency requiring action on the court's part right then and there?
No, Your Honor. I mean, we think that the court rushed to judgment with no good reason. The court should have done a lot more questioning. And what's really was very upsetting to us was that on July 7th, the court may not have had as much information as would have been nice. We agree that the COI that was prepared by ACS was not sufficient. However, there was so much indication that the information was out there, and people tried to tell the judge that it was. And in fact, the AFC contacted the court on the 9th, told the court attorney that we had additional information, that it could be made available. It could be made available directly from New Jersey, from the judge in New Jersey, and the DCPP worker in New Jersey. And she got no response.
Now, going back a moment, is your position now that it should be dismissed for lack of jurisdiction, or that it should be remanded for further investigation as to what's in the best interest of the child?
Your Honor, it's our position that either the writ should be, vacated and the whole thing should be dismissed, and then the parties can deal with it as they see fit, because the child is definitely fine with the mother down in Florida now. There's no immediate need for anything except for the fact that in our opinion, the custody order to the father should be modified, the one from back in March 2021. However, if you were to decide to remit for further proceedings, it's our position that the first order of business should be a decision about jurisdiction, and then see what happens with respect to best interests if there is jurisdiction. I'd also note that the mother has refiled a modification petition now in Kings County, which makes a lot more sense, because if the father actually lives in Kings County, then there's no reason to be in the Bronx. And there are cases relating to the 2 other children pending in Kings County. The case that was put in abeyance to wait for the New Jersey decision on the neglect, which has been pending in Kings County for a long time as to the younger child, and the older child's relative, older sibling, has now filed in Kings County. Well, actually, he filed in New Jersey. It got dismissed because the father said he lived in New York, and he was given 5 days to refile in New York, and did. And those 2
the 3 children, counsel, the 3 children, is the same father and the same mother?
The 3 children have the same father and different mothers.
Right.
All 3.
Exactly. Okay,
and one of the mothers is dead, the mother of the oldest child, and she's currently with an older sibling on a temporary custody order from the Kings County court. She had been removed on an emergent basis by New Jersey before.
No, that's what I thought. I just wanted to be clear that it's the same father with the 3 children, but different mothers.
Correct.
Thank you. You have time on rebuttal.
Thank you.
Yes, I think ACS?
No, ACS isn't involved, Your Honor.
Oh, they're not involved. I'm sorry. Yes. Who's next up?
Bruce Young, on behalf of the respondent mother, Shaquana M. Can you hear me? I'm trying to unmute here.
Yes, you're good.
Okay. So since June 4th, 2021, my client has had care of her 11-year-old daughter. She's doing well. There was safety risk assessments done by the New Jersey investigations of the father that included her, and they concluded there was no danger or imminent harm because she was well with her mother, and even has checked up, and now that she's back in Florida, has checked and periodically checks there. I believe that case will ultimately be closed, although they made a risk assessment in New Jersey, I believe, ultimately in a preliminary hearing, and there's a hearing date in May. Recently, my client filed a modification petition in Brooklyn because there are ongoing proceedings there where this could be modified, and the father has appeared, and were hearings this week, I think yesterday and continuing on Friday, where there's testimony that's ongoing.
So, counsel, what is your position? Should this be denied, or should it be remanded for further proceedings as to the issue of jurisdiction?
You got me, Judge. I'm still trying to figure out one way or the other, and I've been tempering with this thing. I mean, if we apply the strict rules of a writ, there was really no jurisdictional basis except for that the child had temporarily been in New York when the mother picked her up before she moved back to Florida. The father kept manipulating the court, saying, I'm in Brooklyn, I'm in Bronx, I'm in New Jersey, each time to the other court to try to evade investigations and whatnot. So I believe, well, two things. Then there was a stay of the order, and then Judge Moulton on July 7th entered a temporary order under the terms of the stay, saying that the child should remain with my client until further order of the courts. So whatever we do one way or the other, it could impact that, but temporarily until her petition is heard on March 25th in Brooklyn Family Court. So on some level, there really wasn't any contact with the Bronx court except that there'd been this temporary order a few months before. And it should probably be simply reversed and dismissed because the writ should never have been granted. And there should have been at least enough jurisdiction to have a hearing on whether there was jurisdiction and then conclude that there wasn't. And that would be my bottom line.
Thank you. Any questions? No, thank you. Yes, you have to respond.
Oh,
We have one more.
I don't think he's here, Your Honor.
Oh, okay. I thought everyone was present, but that's okay. Then you have your rebuttal then.
Yes, thank you. I mean, obviously, I don't wish to rebut what the mother's attorney is saying on behalf of our client. But I would want to say that one thing I'd like to correct is that the proceedings that took place this week, that took place on yesterday or the day before and are scheduled to continue tomorrow, are the proceedings in New Jersey on the neglect, not proceedings in Kings County, just to clarify.
Well, no, but Mr. Young stated that it was March 25th in Kings County.
That may well be true. I know that she recently filed. I didn't know what the date was. But yeah, that may well be true. And I do think vis-a-vis that, it's important that whatever this court does, it says that the child should stay temporarily with the mother until whatever court is going to consider it does, so that it doesn't fall into a situation where the writ is dismissed, but the father has an underlying custody order that he could try to enforce. So that is a concern that I have.
I don't know. Would reversal result in his still maintaining that custody order?
Yes, I mean, it wouldn't affect it because the reversal would just be of the writ, of the order on the writ that the father was permitted to get her immediately. And the underlying custody order, I believe, would still be there. And like I said, there are modification proceedings pending.
Quick question. If everyone's conceding there was no determination of jurisdiction, don't we have to remand it for the court to make that determination? How can we decide they should have decided it? I mean, doesn't that have to be the next step?
I I mean, I honestly don't have a problem with that. I think one thing, though, I think it's very, very complicated. And I think that the court, that's one of the problems with the court having done short circuit what she did, because because my understanding is that even a writ would be governed by the UCCJA. And the UCCJA, under the UCCJA, as I see it, most likely this child would be seen as a child without a home.
I
And
think, I'm sorry, Mrs. Sweetbaum, I think you need to, you should mute. Can you mute?
Yeah. I did. Let me go back. Let me turn it off and go back on.
Thank you. I'm
okay,
sorry.
that's fine. Thank you, Your Honor. The child would probably be seen as a child without a home state. And they've also got this moving target of where does the father live? And the thing is
counsel,
that,
I mean, our only consideration is the writ and what to do with the writ, and whether there's jurisdiction or not is something, I guess, we cannot make that determination from the record.
probably not, Your Honor.
No.
So, yeah, I mean, I guess Justice Kern is probably correct that that's what needs to happen is first a decision is, except that it's sort of, I'm not sure it's still makes sense because, I mean, the court would have to determine whether there was jurisdiction over the writ at the time it was filed. But the facts of the situation have changed a lot since that date. So
yeah, but we are limited to the record before us. So the fact that things have changed since that date are not things that we can actually consider.
right.
But we'll certainly take a look at it. Thank you both.
Right, but if you could vacate and dismiss, then it would leave everybody where they are now. Yes, is what I'm saying. Thank you, Your Honor. We obviously want it either reversed or vacated or in some way not enforced, and that it be clear that the child's to stay with the mother until something is done.
Thank you very much.
Thank you, Your Honor.
Next
Thank
matter
you.
is Aspen American versus Newman.
This is a Joel Sweetbaum for the appellant. Can you hear me?
Yes, you're still a little muffled, but and he left.
I'm sorry. I'll try to do the best. Can you hear me now?
There you go. Yes, that's much better. Thank you.
I don't. Sorry, what happened here? Yeah, Joel Sweetbaum for the appellant, Your Honors. With respect to the position of the appellants that the Supreme Court order should be reversed, there are two main issues I'd like to bring up to the court. One is the bylaws of the condominium, which are reflected on page 61 of the record on appeal. Specifically, the language which states that the policy shall contain waivers of subrogation. I don't think there could be any issue that was in the bylaws, and it's a condition that.
So, counsel, your position is because the bylaws say they shall be waived, and the policy gives them the right to waive, they have to be waived.
That's correct, Your Honor, and that was the other point in respect to the policy itself, whereas the transfer of the rights of recovery, that if the insured, namely here, the plaintiffs insured the 2900 condominium, waives the right, which they did by the bylaws, that the insurer is bound by that and therefore cannot maintain the action against the defendants, the Newman appellants. I think the case law is clear from this court that the policy here, or that the bylaws here, mandate the dismissal of the plaintiff's complaint. And I just want to refer to one of the cases that we referred to in our brief, on page 11, AIG Property Casualty versus Modi, which specifically in which this court stated that even if the insured's failure to procure a waiver of subrogation as required by the condominium laws, precluded the subrogation action from being maintained. So in sum, Your Honors, our position is that pursuant to the bylaws, the policy itself, and the fact that this is an action by Aspen American on behalf of damage to the building, that they are precluded from maintaining the action. And if Your Honors do not have any further questions, then we will rest on our brief.
Any questions? No? You do have rebuttal, though. Mr. Greenberg?
Yes, good afternoon, Your Honors. This is Elliot Greenberg. I am here on behalf of the respondent, Aspen American, as subrogee of 2900 Ocean.
Counsel?
Yes. I can't
You're
hear you.
You're muted, Justice Kern.
Why is that incorrect based on AIG versus Modi, that because the bylaws require subrogation shall be a waiver of subrogation, and the policy allows for it, that's the end of the analysis?
Because the bylaws do not say there shall be subrogation. What counsel has failed to do is read the full extent of the insurance section 5.4, which is on page 60 of the record. And I quote, and it says, if the same shall be obtainable, the condominium board shall obtain and maintain insurance.
But isn't it obtainable here based on the provision in the policy?
No,
which allows for a waiver?
No, Your Honors, the policy does not provide for a waiver of subrogation. The policy states that the insured may waive its rights prior to a loss, but it doesn't state that it does. It merely states that they have the rights.
Right, but the two together, the policy saying you may waive your rights, so you are allowed to waive your rights, and the bylaw saying if obtainable, you do waive it. Those together, why don't those equal waiver in this case?
Because a waiver of subrogation is a specific contractual clause, which would state that the parties agree that to the extent that insurance is available and insurance is obtained, that the parties waive their rights to recovery. This does not state that, and I refer the court to a case Continental Insurance Company versus 11523 West 29th Street. And in that case, the court stated that the clause which states that the insurance policy authorizing the insured to waive rights against another in writing prior to a loss does not constitute a waiver of subrogation. And I also like to refer the court to another recent decision of the court called Admiral Insurance Company, a subrogate of Lennox versus Timothy Johnson. In that policy, the policy state, we waive our rights to recover payment from any unit owner of the condominium that's shown in the declarations. What we have here is really is the same type of clause that we had in the Continental case. And all it does is it says you may waive your rights against another in writing prior to a loss, but there is no contractual obligation to do that because that is not in the bylaws. Rather, what the bylaws do is the bylaws also have a separate contractual obligation of the unit owner to defend and indemnify the condominium for any damage which results from their negligence. And I'd like to refer the court to page 58 of the record, which specifically states that if any damage is caused by the insured resulting from its negligence, it says the entire cost and expense thereof shall be borne by the unit owner. So there is a separate contractual clause which specifically holds the unit owner responsible for any damage caused by their negligence. And it also says similarly, each unit owner shall be responsible for any and all damage to any unit or to the common elements resulting from the unit owner's failure to maintain, repair, or replace his unit or any portion as required herein. Now, based upon the reports of the fire marshal's report, the unit was in disrepair. It had combustible materials in close proximity to the oven, to the stove. So based upon the contractual obligations of the bylaws, the unit owner is specifically required to indemnify the building for damage caused to the common elements of the building.
Isn't there a carve out there, counsel, for except to the extent that such cost and expense is covered by the proceeds of any insurance maintained pursuant to the terms of these bylaws? That's it, record 58.
58?
It's all right. If you don't have a quick answer, it's okay. It just
I-
seems like that obligation of the condo owners is conditioned.
I believe that this is a contractual obligation of the unit owner to defend and indemnify the condominium for the loss caused by its negligence. And again, I also say that because the clause does not, the bylaws do not contain a waiver of subrogation, but rather say to the extent obtainable, that there was no specific obligation to purchase, to have a waiver of subrogation. And in fact, the policy does not contain a waiver of subrogation, but it says it can waive prior to a loss. And just stating to the extent available, you will get that, you can get this insurance doesn't mean that it does.
Are you saying that the bylaws aren't in writing? You're not saying that, right? I didn't see that in your briefs.
No, the bylaws are clearly in writing, but it says if the same shall be obtainable, the insurance company shall obtain a waiver of subrogation, but it doesn't, but the insurance policy does not contain a waiver of subrogation. What the insurance policy provides is that you may waive a loss prior to a loss, and it's a contractual thing, a waiver of subrogation. If the bylaws.
Yeah, but counsel, again, it was possible to waive it under the insurance policy. I mean, that was a possibility.
It was possible if there was a waiver, but you still need a contractual waiver in the contract, which doesn't exist here. It just said.
Thank you. Any other questions? No? Mr. Sweetbaum, you have 2 minutes.
Yes, briefly, Your Honor. I think counsel was just misinterpreting the bylaws. When he states on page 60, if the same shall be obtainable, the condominium board shall obtain and shall maintain in full force the fire insurance policy. They did. And continuing, as I said before, on page 61, it specifically states each of the said policies shall contain waivers of subrogation. And again, when we refer to page 153 of the record, where it's the transfer of rights of recovery, when it says you, that's the insured. The condominium here waived their right against another party in writing, specifically the bylaws. Again, based on the bylaws and the interpretation that this court must give it, we submit that the action should be dismissed and the action cannot be maintained against the defendants. And again,
thank you. Any questions? Thank you very much. Thank you both.
Thank you, Your Honors.
And so the next matter is the combined matters of 160 East 84th Street, 87th Street Sherry, and 87th Street Sherry versus New York State Division of Housing.
Good afternoon, Your Honors. May it please the court. My name is Jillian Bittner, and I am a partner at Horing, Wellickson, Rosen, and DeGrugier. I represent Appellant 160 East 84th Street Associates in this appeal, as well as 87th Street Sherry Associates. My partner, Ms. Gilbert, will be speaking on rebuttal. The relevant facts before this court, and which pertain to all three appeals, are as follows. DHR issued 2018 luxury deregulation orders based upon high income, high rent prior to the enactment of the HSTPA. There is no dispute that the luxury deregulation orders were proper because the two conditions set forth in former rent stabilization law 26504.1, which requires that the legal rent exceed the applicable threshold and the total annual household income exceed the applicable threshold in each of the two preceding calendar years, was satisfied. The lease expiration was never a condition considered in the effectiveness or finality of a luxury deregulation order. The deregulation orders,
sorry, counsel, don't the orders specifically reference the end of the lease date and say that the apartment will become deregulated upon the expiration of the lease?
The expiration of the lease is irrelevant, though, to the effectiveness or the finality of the deregulation orders and the deregulated status of the apartment, which actually becomes final and binding 35 days after the order is issued if neither party challenges that pursuant to a par proceeding. In this
Counsel, isn't there a distinction, though, between it becoming final and binding between the parties themselves and their ability to challenge it versus an intervening change in law from the legislature? The legislature enacted a law that said it should be applied prospectively, and the deregulation had not occurred at that time the law was enacted. So wasn't in that situation HCR just following the law to be applied prospectively?
The HSTPA, in its repeal of luxury deregulation, ended the landlord's ability to apply for an order of deregulation. There is no language in the HSTPA to indicate that the repeal of luxury deregulation was intended to affect or revoke revoke previously issued final orders of luxury deregulation, which were final before the HSTPA was even enacted.
So what's irrational in interpreting that to mean that if you were actually deregulated before the date of the legislation, you remain deregulated, but if you were not deregulated before the date of the change in the law, then you're not deregulated? What's irrational about that?
So the cleanup bill, which was enacted approximately 2 weeks after the HSTPA, expressly provides that any apartment that's deregulated prior to the enactment of the HSTPA will remain deregulated. This
Right.
apartment.
You just quoted that. That's very crucial language, counsel. Of course, the whole case hinges on that. But that language doesn't say anything about orders. It talks about deregulation or not.
Yeah. Thank you, Your Honor. Actually, I would point to the fact that if it was in fact the legislature's intention to affect previously issued orders such as these, or to use the June 14, 2019 date as a cutoff, the legislature would have said that, and they didn't. And for example, I point you to the fact that the legislature took this exact action in Part K of the HSTPA, where which governs MCI rent increases.
Counsel, this is Judge Gonzalez. So what about the language that says that the act was effective immediately? That's in the cleanup bill, isn't it?
It does say that the act was effective immediately.
So what is, let me stop you. What does effective immediately mean, if not that everything prospective fell under the HSTPA?
The issue with that is that what DHCR's addenda did, or rather what their actions did, is actually not prospective in nature, because the order was final and binding before the HSTPA was enacted. And the expiration of the lease, or rather the way DHCR clarifies it or explains it, is as if it's a condition precedent. It's not a condition precedent for luxury deregulation. The statute, former Rent Stabilization Law 26504.1, as well as 26504.3, make it very clear that only two conditions need to be satisfied for luxury deregulation to be achieved. I also would point to section 26504.3E, which basically says as soon as an owner receives an order of luxury deregulation, they are entitled to serve upon the tenant a fair market lease agreement, which would be the next lease agreement in effect after their rent stabilized lease ends. So there's no real waiting period or no triggering as a result of the expiration of the lease.
They can't charge them non-stabilized rent, though, until the lease is over, correct?
Correct. They wouldn't be able to, which is one of the reasons why it makes sense, maybe not now 26 years later, now that the HSTPA was enacted, but when they drafted the bill, to have this lease expiration, because practically speaking, the lease expiration is needed to trigger the termination of the current rent stabilized lease that's in effect, which is a contractual right that the current tenant has to keep going. It also is necessary because you wouldn't get to this right of first refusal or the ability to enter into a fair market lease agreement. You couldn't just terminate the tenant's lease the moment you got the order or 35 days thereafter. You know, that would be to the extreme detriment of the tenant once these orders were issued. But the expiration of the lease, again, was never a condition precedent. Actually, DHR never even looked at the leases or requested the leases when they processed luxury deregulation orders.
Go back to the MCI.
Okay. So I just also want to go back to the example with regard to where the legislature explicitly took steps to affect a previously issued order and why this is not a prospective application of the HSTPA. In Part K, which governs MCI rent increases, the legislature specifically included language that modified the MCI rent increase cap from 6% downwards to 2% to be applied to MCIs granted as early as June 16th, 2012. So that's an instance where you already have orders in effect, and the legislature was very clear in its intent to affect prior orders. There's no such equivalent language with respect to luxury deregulation orders. The fact that owners could no longer apply for luxury deregulation orders should have no bearing on on final and binding orders. There was no action for DHCR left to take once it issued the order based upon the conditions that were satisfied. It's also.
I'm sorry, go ahead.
No, I'm sorry, Your Honor.
No, you can continue. It's okay.
Okay. It's further obvious that the deregulation orders were not truly conditioned on the expiration of the lease, because as I had mentioned in response to one of the questions earlier, the 35-day deadline to file a challenge to the order begins to run from the issuance date of the luxury deregulation order. It doesn't extend 35 days from the expiration of the lease. I would submit that DHCR and the Supreme Court failed to consider the practical reasons as to why the deregulated status occurs when the lease in effect at the time the order issues expired. Again, nothing which has to do with the effectiveness or the binding nature of the order. When the cleanup bill issued, the legislature was already aware that it had repealed luxury deregulation provisions. It could have, but it chose not to insert lease expiration requirements as a cutoff, because the rent stabilization law never required the lease expiration to have any bearing on the luxury deregulation order. Therefore, I would respectfully request that this court reverse the Supreme Court's judgment, set aside DHCR's par order upholding the addenda, and vacate the addenda. Thank you.
Thank you. Ms. Joseph?
Yes,
Could you address first the issue as to lease expiration and whether that is relevant or not?
If in the former statute 26504.3, it specifically, and the regulation 2531.6 and the order itself specifically provides that upon the expiration of the lease, deregulation will be effective. Therefore, there is no way that in these cases, even though the orders were issued earlier in 2019, the 3 leases in this case didn't expire till June 30th, 2019. So therefore, the apartments weren't deregulated. And actually, the appellate recognized that, because in those 3 briefs on pages 3, 13, and 19, it says their reply brief states there was no action that any party or DHCR could take to preclude the deregulated status from being attained the day immediately following the expiration date for the lease in effect. Clearly.
But Ms. Joseph, they say that they had a vested right, and a vested right can still be something that happens prospectively.
Right, but they didn't have, while they had a vested right to deregulation, it was a right to prospective relief. And that prospective relief became available when the lease expired. That's what that's what the order said. That's what the statutes say, that, or said, past tense, that upon the expiration of the lease, the apartment will be deregulated. It wasn't deregulated. Chapter 9, Section 8 said apartments that are deregulated will remain deregulated. So anything that wasn't deregulated at that point, and in this case, it would be these 3 apartments among many others, because the lease hadn't expired, were not deregulated at that point.
But counsel, were rights impaired under Landorf by this?
No, specifically under Regina and land grant only mandate that they be entitled to prospective relief. You know, under this type of analysis, The deregulation order did not bestow a vested right on the landlord to deregulate the apartment. It only accorded them the right to prospective relief upon expiration of the lease. And if there's no further questions.
Any questions? No? Thank you. So it's 4 minutes on rebuttal.
Yes. Throughout this appeal, DHR stated they could not authorize deregulation because the HCP had repealed deregulation. That is incorrect. What DHR could no longer do was issue new orders of deregulation. The HSDPA did not authorize DHR to revoke final orders of deregulation. That's what happened here. The owner did have...
Counsel, is that in fact what occurred? I mean, was there a revocation?
Yes, because when they issued an addenda, which was effective an order because you could file a PAR, it said that the deregulation was contingent upon the lease expiration, and if the lease expired post June 14th, 2019, your order was no longer effective. So they effectively revoked an order improperly. Because at the time, prior to HSTPA being enacted, the owner knew 35 days after the order, at the very latest, that they had a deregulated apartment, that they could plan the rent for the apartment. They knew that they would offer the tenant a right of first refusal. If the tenant denied that right, that they no longer had to offer any other resident of that apartment a lease, that it was a free market apartment. Based upon DHCR's addenda, they took away that right prospectively, and they made a rent-stabilized apartment for life, because at this point, unless the legislature changes, there's no other mechanism for deregulation. DHCR's addenda created a new condition. As Ms. Bittner stated, there was no condition that the lease for expiration date be considered upon deregulation. There's only two items: the rent and your income. Once that hits, all you have to do is unfortunately wait for the lease, and that's because there's contractual rights. The legislature never wanted to interfere with contractual rights during the parties, but they issued a deregulation order that was final. The cleanup bill could have easily changed that. The legislator was very keenly aware of what was in luxury deregulation, as they had just repealed it. They did not make a condition upon a lease. They just said that you could have no more deregulation orders, that you could no longer apply for deregulation, and DHR could no longer grant deregulation orders. These were orders that were previously granted, final, binding, and there was nothing left for anybody, for DHR to do.
Except that they, in the language of the cleanup bill, they don't refer to the word order at all. It says the act shall take effect immediately, provided, however, that any unit that was lawfully deregulated prior to June 14th shall remain deregulated. They don't say by order of DHCR, which would have been very easy to insert.
They don't need to say that, because if you're lawfully deregulated, whether it be by order or by vacancy, you're lawfully deregulated.
Except that the orders themselves say that the deregulation won't happen until the lease term is up.
But the order themselves, all it does is refer to an event, so it won't interfere with a contractual right. The statute is very clear that the lease has no bearing on whether an apartment is deregulated. The statute says there's two conditions for deregulation. The lease has, in effect, the rent has to be over the threshold, and the tenant of records, a household income 2 prior years has to be over the income threshold. There's no dispute that existed here. So those orders were final and binding. There was nothing for DHR to do. There was nothing to change. All it was that you couldn't interfere with a contractual right. So the tenant would have a few more months to pay a lower rent. The statute itself, as Ms. Bittner said, in 26504.3E says that the owner, no regard to the existing lease, could offer the right of first refusal at that time.
Thank you. Any additional questions? Thank you very much. Thank you all.
Thank you.
Thank you.
The next matter is Brasnow versus Baricua College.
Good afternoon, Your Honors. Sorry about that, my camera wasn't working. May it please the court, David Goldman representing defendant appellant, the Hispanic Society of America. It's respectfully submitted that the lower court incorrectly granted the third-party defendant respondent, Urban Arborist's summary judgment motion. The area which the plaintiff circled in the photograph, which you'll find on page 694 of the record, is the area where urban arborists perform their work. And plaintiff testified that she fell because of a raised area on the sidewalk.
So we're talking about,
I'm sorry?
We're talking about that area, red bricks placed in a herringbone pattern?
Yeah, well, the plaintiff had testified at page 351 of the record that she did not recall if the brick was the red herringbone pattern. Where when she got up afterwards, she didn't look at the area until sometime after her accident. And when she was questioned at 351 of the record, she said she did not recall if the brick was red in that area. So she did circle the area where she fell. On page 694 of the record, you can see the circle.
Anyway, counsel, she didn't have a contract with urban arborists. So we got to talk about Espinal, right?
Correct. She did not have a contract. Absolutely, Your Honor.
So why would they have a duty to her?
Well, the duty, Your Honor, is, it arises not necessarily out of the contract, but by their own affirmative acts in creating the risk of injury to the plaintiff and members of the public.
Acts?
Pardon me?
Did they make a condition worse by their work?
Well, based on the testimony, the condition was worse because there was no such defect prior to her falling.
Isn't there a plethora of evidence that the sidewalk was misleveled before they started working there?
In certain areas there were. Your Honor. Yes, that's correct. But in this area, this specific area, it was where the tree roots were lifting up the sidewalk. And that is specifically why urban arborist was hired. Our client was given the name.
What about the work that they did made the condition more dangerous? What do you claim they actually did to make the condition more dangerous?
Well, based on their testimony and based on the work orders and the invoices, they may have done concrete cutting to cut the bricks. They said that they leveled the area. According to their president and owner, he said they left the area in a level condition. So if it was left in a level condition, then the plaintiff
should not. Did they in fact say that they couldn't leave it in a level condition, that was not something that they were able to do? But under Espinal, you have to show something specific they did, which made it worse than it was before. And I still haven't heard from you what you're claiming they did that made the condition worse, more dangerous than it was before they came in and did their work.
And counsel, what they said was that they did not do anything that would make the bricks uneven or unleveled. They said that existed beforehand. So again, what did they do to make it worse? What is there in the record to show that they did anything to make it worse?
Well, they did something to create a defect because that's what the plaintiff fell upon, according to her testimony. That was a specific testimony.
Counsel, this is Judge Gonzalez. So we know that the work was to correct the tree, to make sure that the tree didn't go outside of the tree pit, and the tree pit was expanded pursuant to measurements provided by the city, right?
Correct. The Parks Department, yes.
Parks Department. So was the misleveling of the sidewalk attributable to the tree roots coming back and lifting up the sidewalk? Did it happen because the sidewalk wasn't properly leveled after this work was done? I'm at a loss because when Mr. Gdansky, who was your maintenance supervisor, asked urban arborists, what about the rest of it? They said, that is all we can go. In his words, that is all we can go. So is the issue here the difference between hiring someone to expand a tree pit and hiring someone to do sidewalk repair?
Well, respectfully, Your Honor, the testimony was from Mr. Logan, the owner and president of Urban Arborists, that his company would go out 1 or 2 bricks to do the work.
But
And
the
that's,
1 or 2 bricks
that's the
was,
exact area that was circled
Counsel,
by
the
the plaintiff.
the 1 or 2 bricks was totally in terms of enlarging the tree well. So there was no work that was conducted to the sidewalk in the area where she fell. That's why that was my initial question in terms of what exactly we were referring to. They did the tree wells, and yeah, they may have gone out a little bit, but not to the area where she stated that she fell.
Well, respectfully, Your Honor, I'm looking at the circle right now. I'm looking at the picture, and she's circling a portion of the sidewalk, but also a portion of the bricks. I mean, a portion of the area that was worked upon. I mean, the testimony was undisputed that Urban did do work in that area where the circle is. Nobody's come in and said that they didn't do work in that area.
Anything else? You do have time on rebuttal.
I'll reserve the rest of my time for rebuttal unless there are other questions. Thank you, Your Honor.
Yes, Mr. Lawless?
Good afternoon, Patrick Lawless for the respondents. At first, I'd just like to point out that the argument that Urban did anything to create or exacerbate the pre-existing condition is being raised for the first time on appeal. The argument that was made below was that Urban had a duty to repair that section of the sidewalk and didn't do it. And the clear testimony of Mr. Gdansky was he supervised Urban's work that particular day. He said, I stood over him, I supervised their work. When the work was completed, he pointed to the area outside of the tree pit and said, what about that area? And Urban unequivocally told him, we can't go there. We can't go outside the city's specs. And apart from just gross speculation and the appellant's own conclusory statements, there's absolutely no evidence that Urban did anything to make the condition worse or to create the condition or to exacerbate it. According to their own maintenance supervisor's testimony, Mr. Gdansky, he said the condition existed before Urban got there and was in the same exact condition afterwards, and he saw it. And importantly, the Hispanic Society accepted Urban's work, never called them back, paid them for their work. The accident happened nearly a year later, and they were aware of that particular raised portion of the sidewalk, and all they did was put an orange cone out there and didn't call anybody to repair it. So under these circumstances, the Supreme Court was absolutely correct in dismissing the claims against Urban. And unless you have any further questions, I'll just rest on my brief.
Any questions? Thank you. Yes, Mr. Goldman?
Yes, Your Honors. The area which was circled on Exhibit A, page 694 of the record, is the area where the roots were uplifting the bricks. And that's the area where Urban performed their work. That's undisputed at page 531 of the record. In addition, the invoice is dated March 12th. The accident occurred December of 2014. So I don't see that as being a year. That's approximately 8 to 9 months. It's based on the test. Pardon me?
That's a pretty long time. And they're seeing the defect and they don't call anyone in to correct it. And the testimony of Gdansky that the defect was there before Urban came in to do the work around the tree pits, and that it was there after they left because Urban said that they couldn't, that was not part of the work. That was not part of the scope of the work. And they did nothing to repair it. So how can you say that it was Urban's fault that the defect was not repaired? They specifically told Hispanic Society that that's not something that they were going to be doing.
Well, it's our position that the plaintiff fell on the area that Urban was working on, where the roots were lifting up the bricks, and that is the area that Urban worked on per
But
Mr.
the area,
Roth's testimony.
wasn't the area that Urban worked on, wasn't that covered by some beige bricks that they cut themselves? And this lady fell on the red bricks, which is not what Urban worked on.
But she testified, Your Honor, that she didn't recall if it was the red brick. She said it was the area she circled. She was specifically asked at page 351 of the record, did you fall on the red bricks where the herringbone pattern is that you talked about earlier? And she said, I don't recall.
But Gdansky,
she just knows that it was the area she circled.
But Gdansky approved of the work that Urban did. That is, that he didn't see that there was any of the bricks that they laid down, any of the beige bricks that they laid down, that any of them were somehow out of step, that they were sticking out in any way. Otherwise, they would not have approved of the work. And the only thing that they noticed was that red brick that had a defect that was present before Urban got to work on the tree pits.
Well, I respectfully believe, based on reading I was not at the deposition, but reading the transcripts, looking at the invoice, looking at the work order, that this is the area they worked on. I don't think that that's in dispute. I think the witnesses agree that Urban worked in the area that was circled, which is the area the plaintiff said she tripped. So if there was a defect there, that was from the work that they did, not from the work that the Hispanic Society did, because they didn't do work to that area. Their work was at a different location on the sidewalk.
Counsel, just to segue on what my colleagues said, or colleagues have said, immediately after the work was done, there were orange cones placed around the defective. I'm going to call it defective for the sake of argument, okay? I'm not making a decision.
Understood, Your Honor.
I'm going to call it defective. I don't know what else to say. Defective area. So there was no recall of urban arborists to the area and saying, look what a lousy job you did, or you have to continue. There was no maintenance requirement. There was actually no guarantee of the work. And in my reading of the transcripts, the whole goal was to constrict the tree from affecting more sidewalk by giving it a larger space to be in. And that work wasn't even guaranteed, perhaps because trees grow by definition. That's why I was asking you before, was the lifting up of the sidewalk attributable to the tree's proper expansion or improper expansion, or was it not a defect that was noted by Mr. Gdansky 3 years before the work was ever done?
Well, yeah, the defect that you're talking about is the whole reason that urban arborist was hired, and the cones that were put out, to my understanding, I thought you were referring to the cones that were put out beforehand that were stolen by, they don't know who stole them, but they put out a couple different sets of cones that were stolen. But my understanding was that the whole reason they hired urban arborists was to take care of this area that was being lifted up by the tree roots, because they're arborists. I mean, in their name, urban arborists. They handled that area, the tree pit, the tree well. There were only 2 names that were given to our client from the city or the Parks Department that could work on this area. And that's why they were hired.
Thank you, Counsel. Any other questions? Thank you, Bill, very much. Have a good day.
Thank you, Your Honors.
Next matter, Schulte Roth versus Metropolitan 919 3rd Avenue.
Good afternoon. May it please the court. Janice McAvoy of Fried Frank on behalf of appellant landlord Metropolitan 919 3rd Avenue. This case requires the court's de novo review of a basic contract interpretation question. analyzing this admittedly complex lease provision to determine if there's any ambiguity by looking at the four corners of the contract. And only if the contract is susceptible of two reasonable interpretations is it ambiguous. Here, landlord's interpretation is the only reasonable one, the only one that does not require a wholesale rewriting of the clause and ascribing different meanings to the same.
Counsel, let me interrupt because I can see two very different ways to interpret this contract. And I think that actually is because of the poor draftsmanship of the contract. And let me tell you the two ways I think it's very easy to read it and why I think it creates an ambiguity, and you can respond. The problem is the part which everyone is arguing creates a second condition for abatement is in parentheses. So it's very unclear from looking at the portion in the parentheses whether that does or does not incorporate the requirement of landlord's breach of an obligation. And if you read it as you wish to as being incorporated, then you win. But if you read it as not being incorporated, which you could do, then you lose. And it's not clear from looking at it because it's not broken off with like a 1-2, but it is in parentheses, which is unusual way to draft a lease like this, and it's somewhat surprising to be honest. But I think that is why there's an argument that reasonable people could differ as to whether or not that breach of an obligation is brought in. So what's your response to that?
I think there are three different ones, Your Honor. The first is looking at section 5.4 in isolation, which is what Schulte insists on doing. They don't want to look at the rest of the lease, and I'll get to the rest of the lease in a minute. But if you look at that parenthetical, and it's interesting, you're right, it is unusual. And this is what Schulte calls a key provision of their bespoke rent abatement clause. Why would you put a key provision in a parenthetical, toss it aside? But if you look at the entirety, there are two parentheticals in all of 5.4. Both of them refer to the unavoidable delay concept. One is in A, the one that Schulte claims is the independent trigger. And then the second is in C. And it goes on to say, you have to meet all three of the requirements, A, B, and C. And C is that such condition, and I'll get to such condition in a minute, has not resulted from the negligence of either party, then the rent shall be abated as to the premises or affected portion on a per diem basement for the period commencing immediately. That's if it's not due to unavoidable delay. Paren, quote, parenthetical.
Let me interrupt, Counsel.
Or on the 15th day.
I think that does support your interpretation, to be honest, the way that C is drafted. It supports your interpretation, but I don't know that it is conclusive because I think many people could read this lease and say that it doesn't bring in landlord's breach of an obligation into that parentheses.
I think there are three other reasons, Your Honor. First, it's a common rule, a canon of instruction and a construction and a common rule of grammar that a parenthetical modifies the entire antecedent before it. The entire antecedent before it is tenant's inability to use the premises for the ordinary course of its business due to landlord's breach. You can't break those up and separate them. They are all
Counsel,
together.
except that the parent, I'm sorry to interrupt you, but except for the parenthetical in this case begins with or, which is a disjunctive, which means it's two separate, it could be read to be two separate things. It's not just that there's a parenthetical, it also says or.
Exactly. One is if there is no unavoidable delay, that's when it begins immediately.
That's an immediate breach.
Then in C.
Right. Whereas
Or,
if it's a breach caused by, I understand your argument. I think there's another way to read it. Your argument is that the or means that after, if the landlord breach is not, or rather is caused by an avoidable delay, then there's this 15-day cure period, right? That's your argument.
yes, but if you go down and look at C, the language is exactly parallel. And that's the one where it says it commences immediately, paren, or on the 15th business day, if such condition results in whole or in part from unavoidable delays. Again, with the or, because there are two separate timing requirements. The predicate cause is always the same. Inability to use for the ordinary course of business due to landlord's breach, but the timing is different. Immediately, if it's not due to unavoidable delay, or if it's due to unavoidable delay after 15 days. And I think there are three other reasons. I keep trying to get to all of them, but that one is that Schulte, in order to get to its reading of this, the first parenthetical, has to incorporate a part of the prior predicate into this parenthetical in order to get to its meaning. What they say, what the parenthetical actually says is tenant's inability to use the premises, right? What Schulte says, well, that means the inability to use the premises in the ordinary conduct of tenant's business. And they're incorporating part of
I'm not really following that argument, because if you just read the parenthetical alone, let's say there's nothing else there, and you're just reading it like there would have been a Roman numeral 1 and 2 there, and you read it alone by itself, it would be a complete thought that if tenants unable to use the premises from unavoidable delays that continue for more than 15 days, the tenant gets a rent abatement, period, without looking to anything else if you read that as a standalone provision.
Except that Schulte says you can't. Schulte says you can't read it in its ordinary meaning because they have to incorporate that ordinary conduct of their business or they don't have a claim, because they were able to use the premises. What their claim is that they were not able to use the premises in the ordinary conduct of their business. In fact, they did use the premises. Their IT folks, their mailroom, everyone else, all the computer people were using the premises. They were able to use the premises.
But then why can't you read it? Why can't you read it? And again, why can't you read it that the ordinary conduct of tenant's business applies to both of those? I mean, the problem really is the drafting here. Because you don't normally have it in the parentheses.
Right, that's the whole point. As Justice Moulton stated, you have the or and you have the parenthetical. So they're in conflict, right? Together, they make no sense.
I think that they're not in conflict. Again, you go back to see with the absolute parallel construction. There's either immediate, if it's not due to unavoidable delay, paren, or if it's due to unavoidable delay after 15 days. And then you look at such condition. And section 5.4 refers to such condition in 5 different places. First, it uses it in the parenthetical. It then uses it all throughout. Schulte says that such condition refers to 3 different things. 1, that it means inability to use the premises. 2, it means inability to use the premises for any cause. And 3, the unfitness of the premises, a word that doesn't even apply. They say that each one refers to 3 different things. The only reading that makes sense, that doesn't lead to a tautology in some cases, is if you read it as inability to use the premises in the ordinary conduct of business due to landlord's breach. That's what such condition refers to. And that's the only way that this entire clause makes sense. The other issue.
You have time on rebuttal. We'll hear from Schulte now.
Thank you, Your Honor. May it please the court. Good afternoon. My name is Peter Wang for Schulte Roth, the plaintiff.
Counsel, I have a very specific question. How, if we accept that your interpretation of that's an ambiguity, how do you make sense of section C, which breaks down the condition where the abatement occurs immediately versus the 15th business day? How does that make sense based on your interpretation of the lease?
I think read as a whole, Your Honor, our interpretation of the lease is that it's a very plain, simple way to read it. There were, in effect, 3 things that could happen that could cause Schulte not to be able to use the premises for the ordinary conduct of its business. First of all, I don't think there's any dispute that we weren't able to use the premises for our ordinary conduct of business. I don't think there's any dispute that that was as a result of unavoidable delays. There's a dispute as to how long that may have continued for, but there's no dispute that that's what happened here, as we all understand. So here there were 3 possible situations. One was if it's caused by landlord's breach, in which case we get a rent abatement after notice immediately. The second is if it's tenant delay, in which case we don't get any rent abatement. And the third was a risk sharing provision that if it was caused by unavoidable delay, which by the definition of unavoidable delay means something outside the fault of either the landlord or the tenant, some sort of catastrophe, just like COVID that caused it, then you have a risk.
So let me ask you a question about what you just said, because you said unavoidable delay has to be outside the control. But if you look at the earlier provision, it says it could be due to landlord's breach of an obligation, except where the breach was due to unavoidable delays.
I'm not sure I'm following that, Your Honor. That's exactly the point, that if you have a landlord breach, then it's a landlord breach and you get.
Well, no, because I'm reading the provision before the parentheses. You certainly can read as saying that if there is a breach, but the breach is as a result of unavoidable delays, then there's no abatement.
No, I don't think, Your Honor, with respect, I don't think anybody's suggesting that the unavoidable delay leads to no abatement. That leads to abatement after a 15-day period after notice. That's the risk sharing that the parties agree to. And as Your Honor pointed.
But the unavoidable delays also comes up before the parentheses. So what's it doing there?
Well, that's a good question, Your Honor. And I think that what Justice Maisley concluded with respect to that is, and I think Your Honor said it as well to my friend Ms. McAvoy, that this could have been written better. I'm not going to suggest otherwise, Your Honor. To me, I read it in plain English, and I think it's pretty clear what the parties provided for. Ms. McAvoy takes her a long time to get there and many, many pages and to describe it, but has a different interpretation. The law, the Telerep case, among others, makes it perfectly clear that if a clause is susceptible of two reasonable interpretations, then it's deemed ambiguous. And I think that what Justice Maisley decided is that in this situation where there's a jury waiver, she's going to be deciding this case ultimately in any event, is that she wanted a full record. She wanted to hear from the draftspeople. I think Your Honor asked the question just now in oral argument, what did the draftspeople have in mind? We are in the midst of that discovery right now. We know who the draftspeople were. And I think that one of the reasons why the appellant is being so strenuous in its arguments here and is appealing this is because they know what the record is going to show. The record is going to show that this was designed for precisely the situation to provide for the rent abatement when there was an unavoidable delay having nothing to do with a landlord breach or a tenant fault. That's what we have here. That's what the record is going to establish. And Justice Maisley wanted to have that whole record in front of her because otherwise she was confronted with two interpretations which she regarded were both two ideas as to how to read it. And in fact, she even said, I can think of others. I can think of other ways to read this besides the way that the two of you are suggesting it. So she wanted to hear from the draftsman. She wanted to hear from the people who negotiated this clause. And that's what we're doing now in discovery. That discovery is going to be completed in about 6 weeks or so. And then we'll be back to Justice McAvoy, calling Dr. Freud. We'll be back to Justice Maisley, and she'll decide it on a full record. Hearing from the draftspeople. So again, Your Honor, I learned long ago that everything I needed to know I learned in kindergarten. That the simple reading is usually the best, and that sometimes I learned later that's sometimes referred to as an Occam's razor way to approach a contract interpretation. Simple is best. I look at this. I put that parenthetical in the earlier part of 5.4 separate. It begins, as Justice Moulton says, with the word or, which is very, very critical, which I think clearly reads to me that there's no possible reason why a landlord breach is a precondition or a requirement for the rent abatement. That is what the draftspeople are going to testify to with respect, Your Honors, and that's what Justice Maisley wanted to hear. So I don't think it's ambiguous because I think that our reading, which is the simple plain English reading, is correct. Ms. McAvoy reads it in a very convoluted way using grammatical terms, which I promise, Your Honor, they don't find their way in any grammatical book I've ever seen. The notion of junction points and this head-spinning use of Romanets, that is a very tortured interpretation of that clause to come to what Ms. McAvoy says is her plain reading of the clause. And Justice Paisley.
Thank you, counsel. Thank you, counsel. We're going to put a period there. Any of my colleagues have any questions? No? Comma, Justice McAvoy?
You are
Who's on mute?
You didn't hear my thank you for the elevation to the bench. I think a couple of things. First, it's Schulte's interpretation that is tortured. And if you look at their brief, it's clear they have to insert words. They have to change meanings in order to meet their interpretation. And what Mr. Wang just called a tortured use of Romanettes is exactly what Justice Kern said would have made this so much clearer. That would have made it clear that this was two separate clauses. That's not what happened. Instead, you've got the parallel parentheticals, or in the case of unavoidable delay, again, referring to
what about Article 24? Because he also pointed out that it's a defined term. Do you want to talk about that?
Exactly, I do. I wanted to get to the other provisions of the lease. First, Article 24, where that unavoidable delays is specifically defined, is clear that it does not relieve the tenant of its obligation to pay rent. And there is no carve-out or reference to Section 5.4. Now, Mr. Wang is going to say, and they should, well, it says notwithstanding anything herein to the contrary, but every other time in this lease, in Article 9, where it says that's dealing with landlord's provision of services, it says tenant will not be entitled to a rent abatement, except there's a carve out in each of those sections. And it says, except, quotes, paren, except as set forth in Section 5.4. So for such a critical key provision that Mr. Wang claims is so critical and key, it's amazing that in the unavoidable delay section, where it says tenant is not entitled to a rent abatement due to unavoidable delay, there's no carve out for Section 5.4. Shocking that they would simply forget it in that place, but remember it 6 other times in the other provisions of the lease. So I think you have to look at the lease as a whole, but B, when you look at this phrase, at this clause in its entirety, it's absolutely clear that that parenthetical in 2 places, or unavoidable delay, refers to the timing and doesn't carve out the key predicate due to landlord's breach.
Thank you. Any questions? Thank you both. Take care.
Thank you.
Next matter is People v. Ken Goodwin.
May it please the court, my name is Zachary Siegel, and I represent defendant appellant Ken Goodwin. Excuse me. In our brief, we raised 3 issues. Given the limited time that I have, with the court's permission, I would like to start with the first issue, and if there's some extra time, make my way over to the third. So regarding the first point, the question of whether to plead guilty is the defendants and the defendants alone. That includes the decision to plead guilty and the decision to withdraw a plea of guilty. And that's because both implicate the defendant's prerogative to decide the objective of his defense, which is keep the guilty plea and seek the mercy of the court, or force the state to prove its guilt. And decisions concerning the defendant's objective in the case, as opposed to, for example, how to achieve that objective, are personally reserved to the accused.
Okay, so counsel, what occurred was the plea judge stated that he could not abide by the plea based upon the new information that was imparted to him. He specifically stated that he would therefore sentence the defendant to consecutive time as opposed to concurrent time. He asked whether or not the defendant wished to proceed, whether he wanted to withdraw his plea, and counsel stated during the colloquy that the defendant wanted to withdraw his plea. The defendant is standing right there, standing next to him, where counsel states that the defendant wants to withdraw his plea. I think he said absolutely when questioned by the court. So why would that not be sufficient?
So to answer your question, Your Honor, I think the first place to look is when Justice Fabrizio directed the question at Mr. Goodwin's counsel. He said, he addressed the question to you. He said to the attorney, do you want to withdraw are you making an application to withdraw the plea? He didn't condition it on the defendant, and he said,
but I think the attorney said we. I think he said my client, if I'm not mistaken. I'm going to look at the colloquy now, but I think he said my client wants to withdraw his plea.
So that, I think, Your Honor, refers to his other attorney. His other attorney was Mr. Horowitz, and he represented him on a separate matter. The cases were consolidated to both plead out that day. So when after Justice Fabrizio accepted defendant Goodwin's first counsel's application to withdraw the plea, he then asked the other attorney, Mr. Horowitz, what do you choose to do? And then Mr. Horowitz said, well, I think I would have to ask my client. And at which point Justice Fabrizio replied, oh, of course you do. And then he proceeded. And then after that, we think this is actually particularly important. What Mr. Horowitz then said was, I can't stand here right now and tell you what my decision is going to be. He didn't say what my client's decision is going to be.
I'm looking at the transcript, right? The court says, okay, so do you wish to have an adjournment to decide whether you're going to withdraw the plea, or do you want me to adjourn it for sentencing? The attorney, Mr. Richmond, if the plea is before you, we will withdraw the plea. And then he said, the court says, if the plea is before me, counsel says, before you, we will withdraw the plea. Again, the court says, I don't understand. The attorney says, if the sentence, and this is Mr. Richmond, not Mr. Horowitz, the attorney says, if the sentencing is such as before you, I am asking that the plea be withdrawn. The court says, so you are moving to withdraw your plea. Counsel says, absolutely. Yeah. And again, the defendant is standing with the attorney during this entire proceeding.
Agreed. So I think, Your Honor, another way, maybe an analogy of looking at this, for example, let's say the defendant was up there pleading guilty in the first instance, and the attorney stood up and said to the court, yes, we want to plead guilty. We want to plead guilty on his behalf. This court would require an allocution of the defendant. It would require conferring and ascertaining with the defendant whether you, Mr. Defendant, are in agreement with this course of conduct. And
okay, so counsel, assuming what you're saying is correct, so what does that mean? He did not want to withdraw his plea. He wanted to go forward and have the court impose a consecutive sentence?
Well, we don't know, Your Honor. I think that's the problem, right? Because no one took the time to
We don't know
actually
whether he wanted a consecutive sentence or not?
Well, we don't know what we do know, because going back to the time.
Okay, so you're saying we don't know if he wanted a consecutive sentence. He received the consecutive sentence after trial, so he got what he wanted.
Well, not necessarily, Your Honor, because the court actually ended up imposing a sentence of 3 to 9 years consecutive, but we don't know whether it could have been, for example, 1 to 3. But even before getting to that, in McCoy versus Louisiana, the Supreme Court addressed a very similar issue, and they didn't get into the weeds of what the defendant wanted and what the defendant wanted. What the Supreme Court said was the violation of McCoy's protected autonomy right was complete.
I understand what your argument is, but I do not understand what the remedy is, and I do not understand what the harm is. So if you could explain exactly what is the remedy, and just to back up a second. So you go before Judge Fabrizio. He says he wants to withdraw his plea, but you're claiming that the defendant never actually articulated this. Case goes to another judge for trial. Does the defendant say at that point in time, "Hey, wait, I didn't want to withdraw my plea. I want the plea to stand"? So that court sends it back to Judge Fabrizio. Again, we're back before Judge Fabrizio. Is there any statement made by the defendant that he doesn't want to withdraw his plea, that he wants the plea to stand?
Well, I think what happened, Your Honor, was in the motion that Mr. Richmond filed when they were before Justice Clancy, was that one of the errors was that they didn't obtain the defendant's explicit consent. And so the judge said, well, I have no power to rule on this. I can't deal with it. They send it back to Justice Fabrizio. But Justice Fabrizio never took the time to actually make the inquiry. Instead, what Justice Fabrizio did was focus on why he was able to withdraw the plea.
Exactly. So why didn't you take Article 78 against Justice Fabrizio? Why, as opposed to doing a 78, do you then proceed to trial?
Well, I think, Your Honor, this is not an ineffective assistance matter. That's the way it seems Your Honor's framing it.
No, I'm not. You're stating that Justice Fabrizio did something that he should not have done. And you're stating that Mr. Richmond included that in his motion. So as opposed to going to trial, which you did, why not take a 78 against Justice Fabrizio, stating that what he did was an error?
Well, I think at this point now, we're past that point, Your Honor, as to what did or didn't do. But I think the important thing to focus on, right, and this is what happened in McCoy as well. We focus on the error and when the error occurred. And here the
So
error.
what's the remedy? So we go to trial. You go to trial now. Again, no statement that he wanted to withdraw his plea, but that's beside the point. You go through an entire trial, jury selection, opening statements, testimony, summations. The jury deliberates. There's a conviction. The entire trial, which took weeks. The defendant is convicted now. What is the remedy now that you're seeking?
The remedy at this point, Your Honor, that we're seeking is to remand it back, or first to vacate his conviction and then put him back in the position he was so that he can himself make, the defendant can exercise his autonomous right to make the decision as to what he wants to do.
Okay, so he says, I want to withdraw my plea. Now what?
If he wants to withdraw his plea?
Yeah, or he says, I don't want to withdraw my plea. So then Justice Fabrizio is going to sentence him to the 3 to 9 consecutive?
Well, we don't know necessarily, Your Honor, what sentence he would actually go through with. I think what happened with part of the motion before Justice Clancy was that one of the issues that Justice Fabrizio found or disabled him from honoring the plea agreement were certain threats, alleged threats against one of the victim's mothers. And Justice Clancy then, she described those threats as unsubstantiated. So I think if we send it back, I mean, if he decides to withdraw his plea, for example, right, and he decides to
Which
go
I'm not even sure he can do since we have a conviction after trial. So I don't know how you would have a plea of guilty, which you would have a plea of guilty and you have a conviction after trial. I don't see how you could have both. But let's assume, for argument's sake, that would be possible. Go ahead.
So if he withdraws his plea, I think just to answer your question a little more clear, I don't think
if he were to withdraw his plea, complete your thought.
Yeah, sure. If he were to withdraw his plea, then he is back in he's in the same position. So I think in that instance, I think that it would be fair for the court to say, okay, you have already had your fair shot. You had your shake before a jury. This was your choice. You have made that choice. And I think there's one way of looking at it to say the conviction would stand and he would be entitled to the conviction and the sentence could stand. I think alternatively, though.
So you just want him to be able to articulate that he wants to withdraw his plea?
Well, not necessarily, Your Honor. I think all I want, and I think all he's entitled to, which the Sixth Amendment guarantees him, is the right to make that decision. And that's what he was deprived of. No one took the time to ask him.
But by the way, counsel, how do we know that he was deprived of that? Because I don't see anything in the record that states that there was not a conversation between Mr. Richmond and the defendant as to whether he did want to have the plea stand. Is there anything on this record, that we can make that conclusion?
I think that's one of the problems, Your Honor, is that the record is barren of any indication of what the defendant wanted.
Why is that, counsel?
I think we place the blame, Your Honor, on the judge. The judge.
What about a 440? Was there ever a 440 done, which would kind of amplify the record?
No, of course, Your Honor. But I understand what you're getting at. And as I was saying earlier, in McCoy versus Louisiana, the state of Louisiana made this exact same argument. They said, well, why don't you remand it back for a 440? Why don't we try and figure out what everyone knew on the record? And the Supreme Court responded to that exact argument and said the violation was complete when the court allowed counsel to usurp control of an issue within McCoy's sole prerogative. Here,
well, I think McCoy, I know you've cited that case a number of times. I think it's a little different from the circumstances in this particular case. And I just wanted to be clear. You are not stating, because you were making reference to the fact that Judge Clancy stated that there were issues in terms of witness intimidation. I did not see anything that you were in any way suggesting that Judge Fabrizio was not within his rights to state that he could not abide by the original sentencing, the initial plea and the initial sentencing based upon the information that was imparted to him in the pre-sentence report, et cetera. You never, you were not arguing that he was not within his right to do so. Is that correct?
That's correct, Your Honor. We're not arguing that. What we're arguing is that, as I've said before, by failing to ensure that Mr. Goodwin understood what rights what was occurring, whether he personally himself wanted to proceed to trial, whether he wanted to withdraw his plea and put the state to the burden, effectively reinstating a second-degree murder charge, or did he want to keep his plea and try and seek the mercy of the court and try and litigate some of the issues that in order to show, as for the state as well, took the position in front of Judge Fabrizio that there were no threats made. So it would have been within Mr. Goodwin's right, his Sixth Amendment right to decide, I want to put myself in the mercy of the court.
But you just stated that you're not arguing that Justice Fabrizio was not within his rights based upon those allegations of intimidation. And that was not the sole allegation. There was also an allegation that apparently the defendant had gang affiliations, which were not made known to Judge Fabrizio.
Yeah, that is true. We are not at all disputing the fact that the judge had the right to withdraw the guilty plea based on those facts. What we are saying is that he did not have the right to accept an attorney's withdrawal of his client's guilty plea without first conferring or ensuring that this is what the client wanted to do. And
thank you. I'm sorry, you do have time on rebuttal.
Thank you, Your Honor.
Ms. Aldridge.
Good afternoon, Emily Aldridge for the People. There is no requirement that there be a colloquy between the court and the defendant in this circumstance. It was obvious that this was a long negotiated process between the court and counsel acting on defendant's behalf. McCoy v. Louisiana is apples and oranges to what happened here. In that case, the appellant, first of all, it was the admission of guilt in the guilt phase of a capital case. And the appellant in that case made clear at every opportunity that he was not agreeing with what his what his attorney was doing. That's not what happened here at all. Up until counsel filed these papers, there's been no indication whatsoever that defendant was unsatisfied with what his attorney did. And as Justice Weber has indicated, the solution is essentially to do what already happened. The plea was 3-9 concurrent, and the Justice Fabrizio seemed to take issue with the concurrent versus the consecutive. And so now we got 3-9 consecutive. So why send this all back for him to get the same thing he's already gotten? And if there are no questions from the court, then I rest on my brief.
Any questions? No, Mr. Siegel?
Thank you, Your Honor. Just to reiterate, in McCoy versus Louisiana, one thing that the court did raise, or one thing that came up, was whether explicit consent from the defendant pleading guilty, whether it was necessary. And they said it was not necessary there because counsel conferred with the defendant first. And there was a record of that made, that there was some conferral, the defendant was involved, he was engaged, he had some say in the matter. And I think what the people seem to be arguing now is that, oh, well, he didn't say anything, so he must have waived it. But a right can't be waived unless you're aware of it. And that's
the question. Was there a right? Is there a right for the defendant to actually articulate, I want to withdraw my plea?
I think there is, Your Honor. I don't think, what would be the purpose of having an allocution what would be the purpose of requiring that a defendant personally enter a guilty plea if his attorney can just withdraw it without willy-nilly? No one asks him,
I think, again, that's the point. I don't know on this record whether you can make the determination that there was not a conversation between the defendant and counsel as to the withdrawal of the plea. And also, would the defendant really want to go forward with the plea based upon the fact that he would now be facing consecutive time? I mean, I don't know, but you know, again, you really, I don't know on this record that he did not confer with his attorney. And again, I'm trying to figure out again what the harm is or what the harm was to your client.
Your Honor, I think focusing on the harm is the Sixth Amendment violation. It's that he was deprived of making the decision. It's not that he incurred any form of specific harm. The harm was that he could not make this decision. The court accepted.
Okay, but there has to be some type of consequence, right? So his Sixth Amendment. You're stating that his Sixth Amendment right was violated. Fine.
Yes.
Okay. So what, therefore, is the consequence of violating this Sixth Amendment right?
Well, in this context, I think the consequence is to remand it, and I think that should be the outcome rather. The consequence.
And we're remanding it. For what purpose?
To give him the decision. It would be as if, Your Honor, if, for example, a lawyer, as I said before, accepted a guilty plea on behalf of a client, we wouldn't be sitting here and saying, oh, well, maybe he wanted to plead guilty. Let's go back and ask him. We would automatically, this court would automatically, it would overturn the conviction and send it back. It wouldn't inquire, well, what harm did he suffer? The Sixth Amendment was violated.
Okay, so counsel, he says, no, I don't want to withdraw my plea. Then now what? We have a conviction after trial. So he says, I don't want to withdraw my plea. Now what do we do?
I think at that point, the district court, or sorry, the Supreme Court then is in a position to decide. I think there are a number of remedies. The court can, one, decide that it could just say, all right, well, your conviction will stand because you wanted to go to trial and you got that trial. And if I may, Your Honor, if they would go back, if that would be the remedy, I would suggest the court also take into consideration the third point on justification, because I do think that in and of itself would entitle him to a new trial.
Okay, so counsel, we're back to the remedy, because I find this to be very, very interesting. We remanded. He says, I did not want to withdraw my plea, right? Then what?
I did not want to withdraw my plea. That means he wants to, okay, so he wants to now keep his plea. I think at that point.
So now what?
Then at that point, he can proceed to a sentencing and they can make
3 to
sentencing
9
arguments.
consecutive to the 12 years, right?
No, absolutely not, Your Honor.
Is that what Judge Fabrizio said he was going to give him?
No, he didn't give a specific number, excuse me. He said it would just be consecutive. So it could have been 1 to 3, it could have been 2 to 5.
And so now
it could have been...
he's going to be sentenced on his plea and he's already sentenced on the conviction?
Well, no, the conviction should be vacated and it should be remanded.
And the conviction would be vacated because?
Because the Sixth Amendment right to make the decision as to whether to proceed to trial was taken away from him. The court allowed it to happen.
I see. Any questions? Thank you very much. Very, very interesting.
Thank you, Your Honor.
I'll use it in my law school class.
Oh, all right, good.
Thank you.
Have a nice day.
DC 37 versus New York City Department of Education.
Yes, may it please the court, Dina Klein for appellants DC 37 and Irina Chernova. As to the first issue on appeal, appellants properly filed their out-of-title complaint with respondent DOE's executive director of personnel as required by the contract. Contrary to the lower court's holding, the contract did not state for appellants to file with the Office of Labor Relations and Collective Bargaining, also known as OLR, and did not indicate that there was any other designee that appellants should have filed.
Counsel, can I interrupt you?
Sure.
They say there was a course of conduct that DC 37 knew the procedure was that OLR was the proper designee and that you'd sent 15 out-of-title complaints to OLR since 2017. So is that like an amendment by behavior of the collective bargaining agreement?
Your Honor, there's no evidence of any past practice. Respondents failed to provide a single piece of documentary evidence showing any of these alleged 15 out-of-title complaints that got filed with OLR. In fact, the practice has been that DC 37 has filed with the executive director of personnel, sometimes referred to by the union and DOE as the executive director of human resources, who for many years was a man named Lawrence Becker, and then apparently became someone known as Tomas Hanna in 2017. So that has been the practice, and appellants actually provided several examples of out-of-title complaints that we had filed previously with Mr. Becker as the executive director, and there was no evidence that the DOE ever objected procedurally to those complaints.
Ms. Genova had one previous out-of-title complaint, correct?
Correct.
How was that handled?
I actually handled that case. It was filed with the same person, the executive director of personnel, Lawrence Becker. And there was, to my knowledge, since I wrote the briefs, there was no objection by the DOE as to what office it got filed. I think what happened is that the DOE got this complaint, and they acknowledged that they received it, and they decided to hang their hat on the fact that maybe the change in nomenclature of the office occurred, and they just felt like, well, we're going to let DC 37 know that we're not going to allow them to just, I don't know what happened, but we filed this out-of-title complaint with the same place that it had always been filed. It's also in this particular contract, grievances are treated separately from out-of-title complaints. And grievances are subject to a 4-step grievance filing procedure culminating in arbitration. And step 4 requests for arbitration do go to OLR, but out-of-title complaints do not. So that was the first issue on appeal. I don't know if there are any questions. I can go on to the second issue.
Up to you if you want to proceed with the second issue.
Okay. So the second issue on appeal concerning the notice of claim, appellant's December 17, 2019 notice of claim was timely because it was filed within 3 months of the constructive denial of appellant's final demand for payment. Now, while the notice of claim had to be filed against DOE and not DCAS, because of the fact that the collective bargaining agreement has a 2-step filing and appeal process for out-of-title complaints, appellants had to exhaust that process before they could proceed to court. So it doesn't make sense why the lower court would have held that the notice of claim accrued at the same time that appellants filed their out-of-title complaint with the DOE. The doctrine of administrative remedies is that appellants had to exhaust that before they proceeded to court. So it doesn't make any sense how under the contract that appellants would have had to file a statutory notice of claim and an administrative complaint at the same time. Because this was Ms. Chernova's demand for payment under the contract for out-of-title higher level work, the notice of claim came due when payment was denied. It's not when damages were ascertainable, as respondents contend.
Thank you. Any questions? No? You have time on rebuttal. Thank you.
Good afternoon. May it please the court, Alan Rosinas for the city respondents. Your Honors, given what happened here, there are really 2 pertinent CBAs, one that applies to Ms. Chernova, who was a bookkeeper, and one that applies to other DOE employees. The second CBA talks about the executive director of human resources, but the first one talks about the executive director of personnel. And according to the
I thought the terms were used interchangeably.
There's no evidence in the record, Justice Weber, that they are. I mean, sometimes in practice they can be, certainly, but I'm aware of no evidence in the record that they are. Ms. Klein referred to.
Counsel, if the collective bargaining agreement says that complaints have to be sent to executive director of personnel, how can that be done if no one knows who the executive director of personnel is? Isn't that a little ludicrous in a way? I mean, they have the right to comply with the collective, an obligation to comply with the collective bargain, and you're keeping it a secret who this person is.
Well, Your Honor, it's a little strange. I'm sorry, Justice Mendez?
To say the least.
Yes, it is a little strange. I think that what I would focus on, Your Honors, is the practical fact that since at least 2016, it has been communicated.
But counsel, there's a clear, before you talk about the practical facts, there's a clear collective bargaining agreement. The parties' behavior is clearly dictated by the collective bargaining agreement. They're entitled to submit complaints, not how you change your mind every week or who you decide is what, but what the collective bargaining agreement says. So aren't you obligated to identify who the executive director of personnel is so they could then file their complaints with that person?
Well, I don't think we are, in the sense that we made clear that it goes to the designee, which is OLR. So there is a
But can
there
you
is an
change your
entity.
mind every week about who it goes to?
What do you mean that it goes to the designee? I don't know. I do not understand. So they send a complaint to the director, the executive director of personnel, and then you forward it to whomever you're going to forward it to? Is that what you just said?
Well, the set procedure in practice is that it goes to an email, a specific OLR email address, Justice
Is
Weber.
that in
So,
the CBA council? Is that
I'm
in
sorry?
the is that in the collective bargaining agreement, that email address?
It is not. It is not, Your Honor.
So I noticed that in your brief, you said it's their own fault. They're just trying to shift the blame. And I would ask you, isn't that what you're doing right now? You, as my colleagues have said, you don't name the person who has morphed from the original title. You don't respond to the complaint. You don't respond to you don't respond to anything. You cross your arms and then you say it's untimely. So what's going on here?
Well, Your Honor, I think that the important fact is that DC 37 knows about this procedure. They have followed this procedure. Ms. Klein says that we have no evidence of that. We do have evidence of that. We have an affidavit from the director of OLR who would know.
Counsel, even if that's true, which I don't think the record does support, but even if it's true, do you have the right, whenever you wish, to just disregard the provisions of the collective bargaining agreement and institute another procedure and tell them you have to comply with this alternative procedure, even though it's not what's laid out in the collective bargaining agreement?
No, Justice Kern, I don't think that there's a right to disregard the terms, but the question is whether or not the terms can encompass a delegation. And
that's what I'm sorry. That's what you were trying to explain this before. I don't understand what you're saying. What your argument is. The collective bargaining agreement specifically says that it's to the DOE Executive Director of Personnel. So if you're going to file a complaint, you're sending it to the DOE Executive Director of Personnel. So how do you then designate someone else with another title? That's what I'm not understanding.
I guess the question, Your Honor, is whether or not that kind of designation can be accomplished consistent with the language of the CBA, and we think it can. And
how?
So, well, because if you have an officer and then that is designated to another body, we don't see that as being inconsistent. If the CBA said this shall not be delegated under any circumstances, that would be different. But right now there's some degree of ambiguity there.
So
and we don't
counsel,
think it's inappropriate.
just to expand, how did you do that? Did you amend the collective bargaining agreement? Did you send a memorandum of some sort saying this person, the executive director of personnel, is now blank? What was the procedure by which a designee was created?
It's not clear, Justice Gonzalez, from the record when this designation first occurred and how it was communicated.
So that's interesting. So it's not clear to you, and it's not clear in the record, but it should have been clear to the petitioners, right?
Well, it's not clear when it began, Justice Weber, is what I'm saying.
And so you're talking about a designee. So to follow it, the collective bargaining agreement says DOE Executive Director of Personnel, but then you changed that to DOE Chief Human Capital Officer, right?
No, Your Honor. What the petitioner, the appellant, sent their the complaint in this case to Thomas Hanna, who is the Chief Human Capital Officer.
And that's because we still don't know who the Executive Director of Personnel is, right?
That's not in the record, Your Honor. And
is it a secret?
As I understand it, that person does not actually exist anymore. So that is that's probably one of the reasons it's been designated. I don't know whether or not it existed before. It's not clear from the record what that position, if that position existed
And so I
before,
want to be
or-
clear now. So the complaint was rejected. Why? Because it was sent to the wrong person?
That's right, Your Honor.
But we don't know who the right person would be?
Well, again, our view is that under the course of practice, there's a designee that's an email address that they have used, DC 37 has used before, that was communicated to them at least 6 years ago, that they have used
Well, I
15
think
times.
Justice Gonzalez asked that question. How was it communicated?
Well,
Was it
again,
a bounce back on the email? Did you
yeah,
bounce back the email? How was it communicated?
Justice Weber, I took Justice Gonzalez's question to be when it changed, how was it communicated? And as I said, I don't know. There is in the record an email from a DOE employee to a DC 37 employee in 2016 that says that that these kinds of grievances, out of title grievances, go to OLR. By the way, grievances, these complaints are kind of grievance under the pertinent CBA as per R206.
So that employee should have sent an email to all his or her colleagues saying, look, guys, if you ever have a complaint, you have to now send it to OLR, right?
I mean, again, Your Honor, I think that the fact that they actually did use this procedure 15 times in a relatively short period shows that they knew,
Right. And this goes back to Justice Kern's question. The collective bargaining agreement itself was never amended to reflect any of these changes. Is that correct?
That's right, Justice Weber, as far as the record shows, yes. Let me, if I may, I'm not sure where I'm on time. If I can just briefly address.
You ran out of time a long time ago.
Okay. May I address the notice of claim argument briefly?
Yeah, I'll give you 1 minute.
Thank you, Your Honor. Just very quickly. They say that in their reply brief, the appellants say that under 3813 sub 1 of the education law, which is the pertinent notice of claim law, that this accrual happened later than it otherwise would have because this is a proceeding for monies due arising out of contract. This is not a proceeding for monies due arising out of contract. There's no breach of contract claim here. If you look at page 29 of the record, what they're saying is that there was a violation of section 661 sub 2 of the civil service law. That is what they're saying is that that the contract was that she was a bookkeeper level 1 and she should have been paid to do the work of a bookkeeper level 2, which is what she was doing. So this is not a proceeding for monies due arising out of contract. And so the earlier parts of that provision are the ones that pertain. And under the case law we cited in our brief, that kind of claim for notice of claim purposes accrues when damages can be ascertained, which here was no later than April of 2019. So if there are no further questions, Your Honors, we ask that the court affirm.
Thank you.
Thank you.
Ms. Klein, you do have time on rebuttal. Is there anything you wanted to add?
Yeah, I just want to reiterate that again, under the contract, out of title claims are not a type of grievance. They're two separate types of challenges under the contract, and they have completely different filing and appeal procedures, and they get filed and appealed to different offices. And again, there is no past practice by which DC 37 had to submit out of title complaints to a particular email address. And we provided documentary evidence showing some of those prior complaints. And we provided 2 affidavits by 2 long-term DC 37 employees speaking to how for many, many years, these types of out of title complaints had gone to the executive director of personnel. As to the notice of claim issue, again, it makes no sense why, if you have a 2-step filing and appeal procedure under the contract, why you would file a statutory notice of claim telling DOE we're going to go to court at the same time you filed the administrative complaint. You can end up going to court before you get the decision from the DOE. And again, that's why the notice of claim was in fact timely. It was filed within the 3 months of the deadline that we had given the DOE to respond, which was October 4th of 2019. Thank you.
Any questions? Yeah, thank you both.
Thank you.
Next matter is Genito versus Shea.
Good afternoon, Your Honors.
Good afternoon, whenever you're ready.
My name is Tim McEnany for the appellant.
You may proceed.
Oh, may it please the court. Respondent's primary argument in this case is that because the appellant's 2015 MRI report, this was drafted a few months after his 2014 line of duty injury, didn't reveal any changes when compared to an MRI he had undergone in 2008. This was for pain which resolved in 2008 and which never kept him from full duty at any point. His current disabling right side radiculopathy, which the medical board themselves confirmed to exist and to be severe enough to be disabling, according to them, could not possibly have been caused by his 2014 line of duty injuries because these two MRIs were so similar. What's particularly interesting about this, Your Honors, is that the medical board arrived at this conclusion despite the undisputed facts that the appellant had fully recovered from his 2008 injuries during 2008 without missing any full duty employment, thereby proving he was not disabled at that time from any condition, and had been performing full duty right up until his 2014 line of duty injuries were incurred. This is also, the medical board also came to this conclusion despite the manner in which the appellant was injured in 2014. His head was slammed into a cement wall and metal pipe by a violent suspect he was trying to arrest before he was crushed to the ground by his partner's body when he attempted to help the appellant control that suspect. The board's determination is also despite the fact that the appellant demonstrated new right side radicular symptoms, which were objectively confirmed as both real and disabling by the medical board themselves and electrodiagnostic studies.
Did the MRI of 2008 also show any type of degenerative disc disease?
We actually don't know what's in that prior 2008 MRI report, Your Honor, because the medical board never saw it. It's only referred to, it's actually just one MRI report that they have. It's the 2015 report. There's a radiologist who reviewed it, issued a report, and says this is substantially similar or unchanged from the prior report. We don't know what that first report contained at all.
Mr. McEnany, didn't Dr. Riley, who treated your client, didn't he also say the same thing?
Dr. Riley, after reviewing the 2015 report, restated its findings, but also attributed causation to the line of duty 2014 injuries immediately thereafter in that report. Despite the fact that there was no change in the MRI, there was a big change. There was a in his physical symptoms and complaints, and those symptoms were not just subjective complaints. They were objectively confirmed. The EMG confirmed he had real nerve damage. The medical board, in reviewing those EMGs, said not only is it real nerve damage, it's disabling. But at that time, the medical board thought that they could use their gap in treatment argument. They
Right,
thought,
I was going to ask, there was a gap in treatment from 2014 to 2015, right?
some, but not what they stated. It's still misstated in the respondent's brief. He treated immediately after the accident, so a doctor immediately after, then conservatively treated up until the time he had his 2017 spinal fusion, which was just 3 years later. And even that amount of time, suppose there was no treatment at all. That's not that big a gap in treatment, not enough to break the chain of causation, certainly. And given the fact that he had continuing complaints during that period, it's nothing close. The court below properly held that that was not a valid argument in this case. Where the court got it wrong below was in allowing the medical board to rely on a single 2015 MRI report for its denial of causation in the face of all these other undisputed facts, which show he did in fact work full duty up until 2014 when he got hurt. He did treat for it afterwards. He was disabled by it thereafter. He had ridiculous symptoms that he complained of only following that 2014 line of duty injury. There's nothing in the record to suggest, there's no evidence at all.
But counsel, I mean, there's an arbitrary and capricious standard of review. So if there's that much evidence that goes against your position, isn't that sufficient for us, or don't we have to find that the medical board and then, of course, the trustees relying on the medical board were not arbitrary and capricious?
Not on issues of causation. There's greater deference paid to them on findings of disability as to whether someone's disabled or not. But here on causation, where the only evidence that they have is controverted by this much other evidence, including the treating physician's diagnoses and attributions of causation, A single MRI report where they haven't even reviewed the other referred to MRI report in that MRI report is insufficient. It's controverted by all this other evidence and their own findings that he's in fact disabled by radicular complaints, which would be spine related. Just because you don't see a difference on an MRI, we're talking about these ghost-like images that have to be interpreted by radiologists. You could have any 3 radiologists read the same films and come up with different conclusions as to what they show or don't show. You see it all the time. IMEs controvert prior radiologists all the time. So it's, reasonable minds can differ as to what they show. But to base the entire denial on that one MRI film, and that's not even a film, they didn't even see the films, they just saw a report. That's the total basis for their denial, with no consideration at all that even approaches Tobin versus Steisel type analysis, where you would say, okay, was there at least an exacerbation of an underlying condition here because of the nature of the injury? His head was smashed against a cement wall and pipe, and then his partner landed on him trying to help him with the arrest. This guy clearly sustained injuries in this incident, and these symptoms weren't disproven. The medical board proved them. They corroborated. Yeah, he's got these real problems. Never complained of before.
You have time on rebuttal. Thank you. Mr. Davies?
May it please the court. My name is Jameson Davies for the respondents. This court.
So is that correct? Are we only dealing with the films on the MRI from 2015?
There's not actually films. Mr. Genito didn't submit along with his medical records the films, but there are reports from his own doctors, both the doctor that reviewed the MRI and the doctor who put in the letter that's saying he's disabled, both of which say the MRIs are identical. There's been no dispute of that ever made to anybody. So every doctor who's taken a look at this has concluded they're identical. But I want to lead off with a slightly different point, which is that the only preserved challenge here is that the medical board's decision was erroneously based solely on a gap in treatment. That's clearly disproven by the Board of Trustees records and by Supreme Court's own decision. And so all of this, the court doesn't need to reach because none of it's preserved. Even if it is preserved, as Justice Moulton was saying, there is sufficient credible evidence in the record to show that, and remember, it's Genito's burden of proving that his disability was caused by the on-the-job injury. At the point where there is any dispute among the credible evidence as to causation, the medical board has the sole authority to resolve those disputes, and that's exactly what they did here. They took a look at all of the evidence. The gap in treatment corroborated the MRI, concluded that this was a degenerative condition, and he had not shown that his disability was caused by the on-the-job injury.
Counsel, one question. With respect to the 2008 injury, is there any clarification as to whether the injury was on one side of the body as opposed to there being a lateral injury?
There is evidence that injury was on the other side, although there's a little bit of difference because even after his later 2014 injury, as we point out in a footnote in our brief, there was a report from the doctor saying it was actually on the left side, not the right side. He says it's only on the right side. But the separate point is that we're not saying that the 2008 injury was the source of the disability. We're saying that as a result of that injury, he underwent an MRI, and that MRI revealed a degenerative disc condition. It's not really relevant whether that injury caused anything. It's just that it allows us to compare the 2008 MRI with the 2015 MRI and say there's no change, there's no indication that his 2014 injury aggravated an underlying condition. More likely that it was the continued degeneration of a pre-existing degenerative disc condition.
When I look at the MRI from 2015, I notice that there's specificity. There's 4 points of comparison listed in the MRI. Was there any challenge to this at any point?
No. All of the evidence submitted said that the MRIs were identical. There was no other evidence submitted, if that's your question. So there's plenty of evidence to show that Genito did not carry what is his burden of proving causation. And I would submit that this is just like the case in Meyer, which we cite, the Court of Appeals case, where a similar degenerative disc condition where the firefighter alleged that he had on-the-job injuries. There was evidence of a pre-existing degenerative disc condition, And the Court of Appeals held that because there was this discondition, the medical board had the authority to resolve that and conclude that it was not shown that the disability was causally related to the on-the-job injury. But again, this is all things that the court does not need to reach because none of this is preserved. And unless there are any other questions, we're happy to rely on those arguments in our brief.
Any additional questions? Thank you, Mr. Davies. Mr. McInerney?
Yeah, I would just say that in the matter of Myers, the medical board in that case wasn't relying solely on a single MRI report. They had more evidence to go on than that. Here, that's all they have. There's nothing else. It's a single report. There are no contradictory readings of it because nobody else saw the films. The only one who saw the film was that one radiologist. That's it. And in the face of the rest of this evidence, the fact that he's never complained of, there's no evidence in the record that he complained of or treated for right-sided radiculopathy or neck pain or had to leave full duty for any other reason before his 2014 line of duty injuries is significant.
What about the fact that the MRI results from 2008, where it stemmed from the injury to the knee, but there was an MRI to the spine or to the back, that MRI is almost identical to the 2015 MRI?
Well, you don't diagnose nerve injury through MRIs. You diagnose it through EMGs. That's how you find it. You get an MRI, you don't know from looking at the MRI whether there are radiculopathic pain issues that have to be addressed. The only way you can find that out is through clinical exams, through talking to the patient, and then through those diagnostic tests. MRIs don't do that. And they are the benchmark for nerve damage. So what we do know is he was not disabled by nerve damage before the 2014 injuries because he was performing full duty. What we also know is that he was disabled after the 2014 injuries from nerve damage that was corroborated by the medical board and deemed by them to be sufficient enough, severe enough to be disabling to him completely. That's why they put him out on ordinary on a 1/3 pension. They shut him out, they pushed him out the door for it. So the fact is, this was not something that was unrelated to work. This was something that was connected by him and his physicians to his line of duty injuries. That's causation under the statutes, under the prevailing case law. That is 3/4.
Thank you. Any additional questions? Thank you very much. Thank you both.
Thank you, Your Honor.
The last case for argument, Canal Rubber versus 6 Green Realty.
May I proceed, Your Honor?
Please.
Okay. May it please the court, I'm Mitchell Zingman of Zingman & Associates, PLLC, attorneys for the plaintiff appellant. We seek to reverse the lower court's granting or pre-answer motion dismissing the 2nd, 6th, and 7th causes of action. The lower court dismissed these claims based on its interpretation of the lease as documentary evidence. In order for under CPLR 3211A1. For the lease to be dispositive, it had to utterly refute the facts in the pleading, facts which had to be accepted as true and given every favorable inference on a pre-answer motion to dismiss. The lower court ignored the very nature of the lease and the long history of the tenant in the building. The premises have been leased to the tenant for an industrial purpose. Article 2 of the lease provides that it's being leased for, quote, wholesale and retail sales, including but not limited to sale of rubber products, close.
So, counsel, my question is this. The causes of actions and you're seeking the preliminary injunction. Is that based upon is that a request to have not only have a key to the elevator, but also to have 24/7 access to that elevator with that key?
I just want to be clear, Your Honor. I thought I was arguing the dismissal of the claims, not the preliminary injunction, which is the other appeal.
Okay, so are these claims dealing only with the key access, 24/7 access? What are these claims dealing with?
Okay. The second cause of action sought restoration of the key to the elevator so that when commercial deliveries came, which in this industry are not not scheduled to a specific time and date, our client would be able to immediately get these thousands of pounds of rubber product into the premises as opposed to being relegated to the stairway. It's not.
So the issuance of the key goes hand in hand with 24/7 access. Is that right?
I guess you could say that, although these deliveries normally occur during business hours and during the week. You know, it was basically commercial deliveries occur like between like 9 and 5 and during, you know, Monday through Friday, not so much 24/7. I mean, my client needed the key not only for these deliveries, but also to deal with people who are disabled. You can't get any, you know, it's the only way of getting people into the premises if you have, because it's a retail store as well. So to get either disabled employees or customers into the space, that's the only way to get them in. The landlord does not maintain staff at the building. If you don't have a key to the elevator, there's no way to do that. You can't schedule days in advance, which is what they attempted to do. Now,
So you're saying, counsel, that there's no access from the street level in front on Canal into the building?
No.
Into the store?
No, Your Honor. There are every other entrance requires going up steps. The entrance on the Canal side has steps. The entrance on the Green Street side has steps to doors. So if you're disabled, you can't get into the premises. You know, that was one of the reasons.
So if you're disabled, you can't get into meaning if you're unable to traverse the stairs, you cannot get into the premises unless you have access to that elevator?
Exactly. Exactly. It's the only way to get in. And for 65 years, my client had a key to the elevator and was able to not only get his product into the premises, he was also able to get disabled people into the premises.
So here's a different question. The elevator no longer goes to the basement. The elevator is created in response in perhaps many ways to the DHCR complaint that was filed by the residential tenants. Given the fact that the elevator no longer goes to the basement, your client is seeking access to the elevator at will so that products, heavyweight deliveries can go through the lobby of the residential area to the store. What does it accomplish?
Okay, well, first, just to refresh everybody's recollection, we do have a claim in this complaint. We're seeking the restoration to have an elevator that goes to the basement. It was removed without our consent. Also, the DHCR.
There's nothing in the lease about the elevator. I understand the issue about many decades of practice, but what is it exactly that you seek? Because I'm kind of at a loss.
Okay, so
let me add on to that question because it goes with that question, which is there a separate cause of action which was not dismissed, which discusses whether or not you have a right, whether the limitations being put on you are unreasonable under the amended rules and regulations, which goes to the question of Justice Gonzalez.
Well, our position in regard to the amended rule is that it certainly was unreasonable, but it was an attempt by rule to strip our client of a right that was impertinent to the leasehold, and that you cannot use a rule to essentially amend the lease.
But do you have a separate cause of action which is not on appeal, where you do address that rule is unreasonable?
I get, in effect, yes, because we're basically seeking the restoration of having the key so that we have access to the elevator, and also restoration of the elevator to go to the basement. You know,
what does the lease say about this? What does the lease say about your rights or lack thereto, the key, access whenever you want access? Does the terms of the lease themselves address this at all? Other than that, you have a lease to the basement?
Well, I mean, the lease certainly granted the entire basement to my client, which included the elevator, included an exclusive ability to receive deliveries
But is
there.
there anything else in the lease that addresses this other than the fact that you have a lease to the entire basement explicitly?
There's nothing in the lease that provides, that addresses the issue of the key. So the
Okay,
question.
other than the history, which I'm not putting that aside, but there's been a long history of your access, other than the history of that you had access all these years, what else is the basis for your argument that you have these rights?
Well, so I guess our position is that, again, for 65 years, including 3 years under the current owner, we had basement service to the elevator, and we had a key to the elevator, and that it's necessary to the use and enjoyment of the premises for this particular industrial purpose.
So, counsel, let me ask you this a different way. So, in the past, before you lost access to before you lost the key, before the key was taken away from you, did you roll or move supplies and deliveries from the street level on Green Street through the lobby to your store?
Well, before they took away the key, before they changed the elevator went to the basement. So normally what we would do with street level access, we would use the elevator to get these thousands of pounds of product into the basement. It wouldn't have gone through the lobby. When they eliminated the basement service, the elevator is still there. If we have the key, if we had the key, we'd have no choice. In order to get it in and not use an internal staircase, we would take it up in that elevator and then take it through that lobby into the rear entrance of the client's store.
This lobby is shared by the commercial tenants and the residential tenants of the building, or this is a teeny library lobby that only you have access to?
The lobby is shared with the other tenants in the building, but because of what they did in stripping the elevator, in changing the elevator, so it only goes to that one area. They're the ones who eliminated our ability to take it to the base, which is what we prefer.
So I have a question. So even if you got the key back and you got access to the elevator back, you still couldn't use the elevator at this point to bring your product down to the basement, right? Because it doesn't go to the basement.
No, I mean, we do have a claim to compel them to restore basement service.
Right, but separate and apart, what is 24 access to the key and the elevator going to do in terms of assisting you of getting your product down to the basement?
Well, it's not 100% improvement. It's at least we could, first of all, if you don't have the key, then it takes hours to get it off the street into the store. At least if we had the key, we could get it into the main level, the retail level, so it's off the street. And then gradually over time, they could get it downstairs.
So no matter what, you still have to take it down the stairs. Whether or not you get the 24 access, you're still having to get the stuff down to the basement using the stairs.
But not like on a forced march and not immediately. And we have the option, because it's a lot of space upstairs also, if we wanted just simply to leave it on that level. It's still better than nothing. You know, they took away all of our rights to the elevator, essentially.
So when you talk about not using the elevator and getting to the store, you have to walk up the 3 flights of stairs then to bring it in? Is that, I don't know, is it 3 flights of stairs? Is that what you're talking about? The difference between using the elevator to get into the store versus using the stairs to get in the store?
If you don't have, well, it's all very awkward. If you don't have the elevator and they've locked the Green Street doors as well, which is the oversized double doors, they have to literally take it off of Green Street, go around the corner, climb a series of steps into the main entrance of the retail store where customers will be coming in. And then you have to then take it down, either find some place on that main level, or then you have to then go down a series of steps in the internal stairway to deliver.
So I'm sorry, counsel, I'm confused now. I'm not understanding how access to the elevator assists you. So you have, the way it is now with the elevator, how does that assist you in terms of bringing things in and out of the store?
So the commercial carrier will come to the Green Street side of the building where the elevator is.
And this is also where the residence is, right?
Well, it's commercial. I mean, it's offices, and there's some residential
Okay.
tenants. And I just want to also say, they weren't required to change the elevator because of DHCR orders. The DHCR just wanted them to restore the freight use, not change the elevator.
Okay, so we're at Green Street now. Go ahead.
So you're at Green Street. If we had a key, commercial carrier comes in with 2,000 pounds of rubber products. They open the elevator, they get it all in within 12 minutes. They take it up to the lobby level, then bring it into the store, and then I guess either they leave it in the store, or if they want to, they can take some of it that they may have to take down by stairway to the basement. But it's still better than taking hours.
So now that you don't have a key, you have to take it through the front door of the retail establishment.
That's right, and that's hours, and that's just hours of work. And it's also very risky for the people involved. It means you have to use a lot more people, and it's dangerous.
Counsel, and is there also access via stairs on Green Street to the basement?
Well, no, there's no stairway to the basement. On Green Street, there's stairways to a double door that used to allow the tenant to bring oversized products in without having to cut it up on the street.
Like, if you use the Green Street entrance now, can you take your products, the deliveries, down stairways to get into the basement?
You would go upstairs to the double doors. You go into the back door of my client's space, and then there's an internal staircase to go to the basement. There's no direct stairway from the street to the basement, if that's what you mean.
That's what I was asking.
Thank you, Counsel. You have time on rebuttal.
Thank you, Your Honor.
You're muted.
Oh.
No, not you, Mr. Pennsylvania. There you go.
Appreciate it. Thank you. For the defendant respondent, 6 Green Realty Owner LLC, Michael Pennsylvania, Rosenberg and Estes. May it please the court. And what I'd like to start with is to address what I perceive to be the court's concerns with the case, and to Justice Kern's point and to Justice Weber's point. There are other causes of action dealing with larger aspects of this case that are not before this court. The narrow issue before this court is whether or not the defendant, whether or not the tenant is entitled to a key to the premises, and that key was described.
Let me ask you why, based on the fact that the tenant has been using the elevator and the side door during its whole tenancy, and clearly its life is much more difficult in terms of moving things in without that access, why hasn't it become pertinent to its lease premises?
Very good question, Your Honor. And I think a little background is required for that. First and foremost, at the time that the plaintiff operated the building, it was a family-owned business, and there were just a few rent-stabilized tenants in that building. My client purchased the building with the intention of actually using it for mixed use. So that elevator, as a freight elevator, which otherwise solely serviced the tenant, the plaintiff, is now required to service other tenants in the building. And that has to be managed by the owner of the building. The tenant can't have a key to that elevator for the sole purpose of determining when it wants to use the elevator and using it for whatever length of time it requires, to the detriment of everybody else in the building. And if you...
How do other people get to use the elevator? How do the other tenants in the building get access to the elevator? Do they have to make arrangements like...
No,
So how do they all get access?
The residential tenants in the building go through the Green Street entrance into the main lobby, and they're able to access the elevator from the main lobby of the building up to their apartments.
And why can't this tenant do that?
For a number of reasons, Your Honor. First and foremost, let me be clear. The tenant can do that. And I want to be clear about something. What this cause of action concerns is giving the tenant a key, not giving the tenant access to the elevator. Okay?
Well, that's
The
a
tenant-
little confusing because
Yeah,
I'm
so I don't understand. What do they need a key for then? If everyone has equal access to the elevator, meaning anyone can get on the elevator, what is this key for?
And that's a good question. And I would answer that, Your Honor, because what Mr. Zingman stated was that he needed immediate access to the elevator. He was unwilling to wait 15, 20 minutes, however long it takes to coordinate that elevator use.
Wait, I'm totally confused, counsel. Aren't there these new rules that says if this tenant wants to use the elevator, they have to go through a lot of crazy steps to be able to use it?
2 days.
Notice, two days notice. Isn't that inconsistent with what you're now saying, that this tenant can use the elevator like everybody else in the building can use the elevator?
I don't think so, Your Honor, and I'll explain why.
Don't you have an hour limit too, counsel? Don't you say that it has to be used outside the hours of 9 to 6?
No, it's the preference of the building to accept these deliveries during certain times. And keep in mind that these rules don't only apply to this commercial tenant, but other commercial tenants in the building as well. So there's one elevator being shared among multiple commercial tenants, in addition to numerous residential tenants and office tenants within that building. So
And nobody has a key? Nobody has a key to the elevator?
Well, let's talk about what the key is. Okay.
So I think what you're talking about with the key is meaning the key takes it out of service, right? The key means that it's no longer that it has to be operated like a freight with that key. Is that what it means?
In this sense, what the key means is having access to that elevator directly from the street level. Nobody has that. Nobody has that except for one disabled residential tenant who is able to do that. And that's the policy of the building for security purposes, not to have anybody coming in and out of that elevator going up to whatever floor they want.
So, counsel, when you say the street level, are you talking about the lobby level? You're talking about, is that a separate level? How does this go?
Okay, so I'll explain. The entranceway on Green Street, where the residential tenants enter the building, consists of a stairway that goes up. There's stairs that go up a half level, and that's the main lobby. And they could access the elevator directly through that lobby. That elevator also goes down another half level, equivalent in the height with that staircase. So it accesses through a side door outside at the street level.
So they can use the elevator in the lobby, they just can't call the elevator to the street level.
Correct.
Guys, other than this one tenant who you say has a disability.
Correct. And my
You also mentioned, counsel, that there are other commercial tenants in the building. The other commercial tenants in the building, you stated they also don't have the key access. Is that correct?
I can't. I'm not aware of the other commercial space being rented, Your Honor. I know that there is other commercial space, but I have seen a lease. My clients asked me about a lease, and we've used the identical set of rules for every incoming tenant into that building. So they're all subject to the same rules because this one elevator has to be used by everyone, and that has to be managed by the owner of the building. We can't have a tenant take control over that entire process because they want immediate access.
So, counsel, I assume that I'm going to assume that there's no other tenant there, no other commercial tenant who's been there 65 years. Would that be correct?
There's no other commercial tenant who's been there, Your Honor, who's also owned the building as well. That's correct.
Right. And in the past, the owner of the building had exclusive use of the freight elevator, and the other tenants didn't have access, right?
Correct. All of the access the other tenants had to go through the tenant's principal, Mr. Landsman.
Mr. Landsman.
And that was the issue, that he was acting with two hats on. He was both the tenant and he was both the owner. And he was there on a daily basis operating this building as the owner. And I think what's important for the court to understand is that.
Can we go back to the key, please? The key is, if I'm understanding this correctly, is the equivalent of the fireman's key, the fireman's access key, or is it not?
I think a better way to think of it is a fob. It's not a physical key, a fob, an electronic activated device, a fob that activate certain permissions on where you're allowed to access a building. So that fob, if you will, would not work from the street level for anyone. It would work from the lobby level because there are access points that are being controlled by the landlord.
But unlike the fireman's key, it's not going to turn the elevator into purely from a manual to it has to operate only with the key.
Right.
Correct.
Do you need that key in order to go from the lobby to street access? Do you need to have the key with you if you go to the lobby and you press the button and the elevator opens up and you want to go to street level? Do you need a key in order to go to the street level?
Yes, you do, Your Honor. That street level access is restricted because, again, the concern is having doors open up that aren't otherwise secured to the street and having anybody come into the building outside of the building security measures.
So that also means if they're bringing a delivery and they leave it open for an hour, someone can just walk into any part of the building.
That's correct, Your Honor. And that's why, you know, there are a number of reasons why my client would like to manage the tenant's use of the elevator. One, it's a passenger elevator that needs to be converted to freight use and to protect it and to manage that security issue as well, in addition to other issues.
But can the tenant use it? I'm sorry. Can the tenant use it if they're willing to go up to the lobby and then press it like anyone else does and go to their store?
This commercial tenant can get access to use it from the street level up to the back of their store premises. That's correct.
You have no objection to the commercial tenants moving their deliveries through the lobby. That's not part of this.
It's not part of this case, Your Honor, because my client really doesn't have any other way to provide that service for the tenant, and it's willing to provide that service to the tenant. Again, you know, in my mind, the issue is with the fob and the key is a matter of control and ownership. And here, the tenant's principal is just unwilling to relinquish that level of control over the building. And it's especially clear when there's really there hasn't been any dispute. And I would, you know, direct the court to the record, which is completely devoid of any request to access the elevator or any instance when elevator service was not provided to.
Let me flip what you're saying on its head, please. So is there anything in the record that says that the deliveries took more than 12 minutes? That was an interesting representation, at least for me, that it would only take 12 minutes to load the elevator. Is there anything there to indicate that it would be more than 12 minutes and inconvenience the other tenants in the building in any way?
Mr. Zingman himself said that this is a process that could take hours. I don't know if it takes 12 minutes. Again, there's nothing in the record to suggest even the amount of material being brought in, the frequency. It's the affidavit of Mr. Landsman. And there's nothing in the record substantiating anything that he states in his affidavit, which I believe should have been there, could have been there. It's certainly information within his control. It's just not there. This is simply the word of Mr. Landsman characterizing tons of material, whatever that means, or thousands of pounds of material, without substantiating it. And it's completely devoid from the record. And by the way, the tenant has, since this appeal was briefed, requested access to the elevator a handful of times. That access was granted to him almost immediately and certainly within 20 minutes. A handful of times access has been requested throughout this entire action. And there's nothing in the record stating that access was not otherwise provided.
Thank you, counsel. Thank you very much. Mrs. Zingman, you have 2 minutes.
Okay. First, the claim that access was provided in 20 minutes, that's not in the record, and access has been repeatedly denied. And I pointed out in my
counsel, is there anything in the record going along with what your adversary was just saying? Is there anything in the record to indicate when access was denied? Or alternatively, how many times a day or a week you would need access?
Two things I want to make sure I point out. One is that this is the issue here is whether they should be dismissing a pre-answer on a pre-answer motion, a cause of action. So I'm not sure that's really a fact question. But the other is that in our pleading and in our affidavits, we say we requested access, it was denied, but also that the rules they gave us said, don't bother asking us. Here are the rules. You must give us 2 business days notice. They don't say, we'll think about it. You have to give us 2 business days notice, and you have to deliver either before 9 a.m. or after 6 p.m. And in our pleading, we repeatedly state, we basically have put them on notice. That's not possible. And that's why we need access. The problem is they don't maintain staff at the building. The landlord changed this elevator because they don't maintain staff at the building. So there's nobody there to give immediate access or even 20 minutes or a half hour. And in fact, when we argued this case orally, I said, so are you rescinding the rule? Will you give us this access? Are you telling me somebody will be there that same day? And the answer was no.
So is there anything in the record that corroborates your adversary's statement that access was provided within 20 minutes or less?
There's absolutely nothing in the record. That is something that the only thing that's in that where that appears, it shows up in his appellate brief. I also want to point out, if you listen when he first was making his argument, he's made a critical concession. He admits this owner came in the building to change it completely despite the existing tenancy. He came in there with the idea of stripping away the freight elevator and changing the entire complexion of the building at the expense of my client.
Didn't DHCR's order have a role in this? Because when the new landlord applied for rent restoration, those applications were denied twice because the issue of the elevator still hadn't been resolved.
That is a misstatement by the other side of the DHCR.
I looked at the orders, counsel.
Yeah, no, the DHCR orders basically said what happened is after they took title to the building, they didn't maintain staff, and it's a manual freight elevator. So the tenants in the building could not get any use of it, any use of the elevator because they didn't have staff there. So because there was no freight elevator service, they filed not during the prior owners of ownership of the building. Under the current landlord, 5 months after they took title, they filed complaints with DHCR. And DHCR, if you look at those orders, they basically say, well, they're keeping it locked up and they're not providing any service. And that's why they had a rent reduction. There's nothing in the order that says you have to change the elevator, you have to provide a residential.
Captain, let me ask a question. How do you respond to Article 13 of the lease, which says that the elevator is part of the building subject to control by the landlord, which may at any time change its arrangement and or location? Doesn't that express lease provision undercut the argument that you're attempting to make here?
No, I don't think so, Your Honor. It doesn't say they can, it talks about changing.
Its arrangement and or location.
Yes, arrangement and location, but that doesn't mean eliminating an appurtenant right to the leasehold. It might mean if you're changing the doorway, it's not eliminating a complete access, particularly when for this particular industry where he needs it for the use and enjoyment of the premises, that he needs that access to the elevator to be able to get these goods in. And it goes hand, in the overall context, they remove the elevator, they eliminate basement service, they eliminate 2 out of 3 points of access. It's part of an overall plan to essentially force this commercial tenant out of the building because they wanted.
Thank you, counsel. Thank you very much. Thank you both. That concludes your oral arguments for today, February 3rd, 2022. Have a great day. Thank you.
Thank you, guys.